See, I beg to mention item number 45. I'm the respondent number 5. I took the consent from the petitioner.
Who is the petitioner?
My lord,
Where is the petitioner?
I took the consent of the
You
petitioner.
see, the problem is, yesterday also we had adjourned the matter and they
Yes,
had said
adjourned
that
the
they have taken the consent. Then the
Yes.
other side comes and says that no consent was taken.
No, my lord, already, if he has come to mentioning the some other.
You bring that other side.
My lord,
Made to the lordship. Lordship, with the consent of the other side, I beg to mention item 58. Other side is here, lordship.
Item
Item 58, review petition, lordship.
58.
Lordship, they have filed an affidavit in opposition. We need some time to file a reply. Kindly 2
Okay,
weeks time
okay.
to be
Miss, your name is
granted. M. Devi, lordship.
M. Devi,
Lordship.
Learned Counsel for the
A state, lordship.
state. Is granted
2 weeks time.
2 weeks time to file affidavit in opposition.
Reply, lordship.
Affidavit in reply. This is a matter after 2 weeks.
Lordship, may I pray for a fixed date, lordship? It's a review petition, lordship.
It will come, it's a review, it will come. It
Any
can't
date-
go anywhere else. Yes, next.
May I please, your lordships? Lordship, I beg to mention for listing of a matter for admission, my lord. As
No,
per-
go to the registry.
on it. I have already approached, my lord. Matter has the.
No, there's too many matters. We cannot, we can't complete our list.
My
Let
lord,
the
as per last
registry.
order, my lord, matter is supposed to list before, immediately after registration. Are not listed, my lord.
You wait your turn a little bit.
May I please your lordship? My lord, I am saying for listing a date petition regarding no confidence motion for admission hearing. Otherwise, my matter will become in fact the December period will be over. Lord. I have been removed from the post of resident illegally, lordship. That's why last posted it was 27/3/2023. It was directed to be listed after
Have you gone to the registry? You
I
go to
have-
the registry and ask for listing first. You go to the
lordship,
registry.
after
You
two
go
weeks,
to the registry,
this
yes.
I-
Web letter, listing motion letter,
What
Friday,
is, for when?
Friday.
What is the matter about?
Matter, my lord, pertaining to settlement, settlement market by Panchayat man.
May I please, your
Hi there.
lordship? Lordship, I beg to mention item number 2, 3 and 4, lordship.
2, 3 and 4.
Yes, lordship.
Yes?
Lordship, similar batch of writ petition is already heard by Honorable Justice Pathak, lordship, and the judgment is reserved. So may I pray for adjournment of the matter, lordship?
But this has been reserved for a long time. We will issue notice then at least. We cannot keep it pending in the motion stage. We'll issue notice. And then we'll keep it. Okay, right. Heard Mrs. L. Barwa,
M. Bora.
Ms. M. Bora. Ms. M. Bora, learned counsel for the petitioners. Issue notice returnable in 4 weeks. Ms. M.D. Bora accepts notice on behalf of the
Yes, ma'am. 1, 2, 3 and 4.
1, 2, 3 and 4. Full stop.
5 is a private respondent.
Petitioner takes steps for service of notice upon the respondent number 5 by registered post with AD within 2 days. The next para, the counsels for the parties submit that similar matters have been heard by a coordinate bench and judgment has been reserved. Accordingly, they pray that the matter will be listed after 4 weeks. This is the matter after 4 weeks.
Obliged.
I'm deeply obliged.
Item number 5 to 11, man. But here notices has already been issued. It is wrongly listed in the admission column, man. Can it be in the admission column?
How does it matter? The issue here is very small.
My instruction is evident, man. Can it be, man, after 4 weeks? I have taken the
There-
consent. There is a
You have
speaking order. I will have to defend that, man.
speaking order, but there is a judgment of the court.
The event that, man, there. I will
They are
like to find out
similarly
what the
placed individuals as the petitioner, as those persons in the before the decided case.
Let me file one
Is it-
affidavit short affidavit.
What affidavit are you going to file? I think you have filed already.
No, my lord, in Digboy Carbon we have filed, but my lord, in 5 to 5.
It's the
7 to
same thing,
11.
basically the same thing. That's the stand you've taken. Just give me item number 5.
Yes.
Who's appearing for the, yes. What is you have got no objection or what?
Your lordship, on the last occasion also, they sought time to file an affidavit, your lordship.
Or she may fix a date, my lord, on a hearing day, my lord. Since my lord, there is a speaking order, I will have to, my lord, make a submission. Let it be
You
next.
see, you have already filed an affidavit in 6864.
No, that is item 6.
Huh.
6,
So,
8, 6.
so it is the same. The issue, your stand will be the same in all the other. I mean, there's no difference in the facts. Then what more do you want to file? It's just a delaying tactic.
Then Lordship may fix it tomorrow, my lord, for hearing or for final disposal, or my lord, next Tuesday, any day, my lord. Not on a motion. then. We do not object.
Okay, right. On the prayer of Mr. B. Gogoi, Learned Counsel for the State Respondents.
My lord.
This is the matter on
Tuesday, my
16th,
lord. Tuesday.
16th,
Lordship.
16th, in the admission column.
Lordship.
Notice has been issued, no?
Notice has been issued.
No, huh?
Yes, sir.
No. In some it is issued, in some it is not issued. That's why it's here. Like item 4, no notice was issued. This is matter of 16th.
My lord.
I don't know. I think it is your case that they are all similarly placed.
No, my lord, our case, my lord, there are some technical grounds, there are delay on their part, my lord, in making the application for refund.
Huh?
There is a limitation, my lord, in making the application for refund. So that is the ground, otherwise. They are otherwise fancy dress, my lord. When they approached, my lord, they were sitting tight, man.
Otherwise, I mean,
Legally, yes, Parag.
legally,
But, my lord, they will have to make it. clear,
so the only question
my lord.
is whether the judgment regarding fence sitters will apply to them.
Yes. but
That
then
is
also
that is their
the
only case.
provision of limitation. They will have to apply for.
Yes,
refund
I mean,
within
the
5
facts of the
as per
case,
the
I mean, it's settled.
Yes.
The law is settled
Otherwise, no
and they are
issue.
covered. Only thing is that since they have come late to this court,
That is the ground in the speaking order.
that is the only thing, I think.
May I plead,
May please, your lordship.
may I plead your lordship? Lordship, I beg to mention item number 54 with the concern of the other side,
Where is the other side?
other side.
Yes.
2 weeks time may be given lordship.
For what?
Lordship, for, it is for order, sir. They have to, respondent number 6, 3, 4 and 5, they have to file affidavit, lordship.
Yeah, for?
IOCL, 1 and 2.
Who is for 3, 4 and 5?
They have not. 54.
I'm taking
Adjournment.
You are for whom?
3, 4, 5.
3, 4, 5.
When are you filing your affidavit?
Your Honor, I also came to take an adjournment because we are not getting the certified copy we have applied for.
When will you file?
Within 4 weeks, Your Honor, we will.
4 weeks. Why 4 weeks?
Your Honor, actually, the thing is that we are not getting the copies from the persons where we have applied for.
Who are the persons you have applied from?
Actually, in the lower court, we have applied and we have not get.
No, I don't think that is no excuse.
2 weeks.
Yeah. You go apply from, it will be given to you. I don't think you can be denied. You're not pursuing the matter, that's why. Mister? Your name?
SP Chittawat.
SP
Chittawat.
Chittawat, Learned Counsel for the response number 3, 4 and 5 is granted 3 weeks time to file affidavit in opposition. List the matter after 3 weeks.
Lordship, respondent number 6 may be also directed to file affidavit.
Who is for respondent number
This
6?
is explosive department, Lordship. That is very important, Lordship.
But who is representing?
Not appearing, Lordship.
Huh?
Order may be there, they will file, Lordship.
But who is the counsel?
Council is SS Roy. I have seen that.
Mr. S.S. Roy, Learned Counsel for the respondent number 6 shall also file affidavit in opposition within 3 weeks.
Deeply obliged. Much obliged.
Lordship, I beg to mention item number 16 of today's report.
Yes,
There's some difficulty on the part of the engaged counsel, Lordship.
yes.
Can be taken after 10 days. Lordship, I've taken consent of the other side.
Who's the other side? Okay. On the prayer made by Mr.
P. Das.
P. Das, Learned Counsel for the petitioner, which is not objected to by Ms. B. Sharma, CGC. List the matter after
Lordship, 10 days.
10 days.
Much obliged.
May please, Lordship. Under respondent number 5, my petitioner is.
Okay,
I'm for the
for item,
item number 45,
on the prayer for adjournment made by Mr.
RC Paul.
Huh?
On behalf of AK Prakash.
made on behalf of Mr. A.K. Purkasta, learned counsel for the respondent number 5, which is not objected to by Mr. S. Sakya.
My lord.
This is the matter after.
4 weeks, my lord. I
4
filed
weeks.
an additional. We have
4
already filed an affidavit additional.
In the meantime, the respondent number 5 shall file an additional affidavit.
Much okay.
Lordship, I beg to mention one repetition, Lordship, matter pertaining to settlement of heart.
You go to the registry, ask for file. Ask for listing, settle. It is a pending matter, correct?
Lordship.
You go to the registry. Next.
Please, Your Lordship, I beg to mention for listing of a writ petition for withdrawal.
Okay.
The grievance of the petitioner has already been settled by the respondent.
Yes, allowed. It will be listed tomorrow.
This matter, the term to be ended in next 30 June, Lordship.
I go to the registry. Have you gone to the registry earlier? You go to the registry first.
Wait, please, Your Lordship. With the consent of other side, I beg to mention item number 38, 39, and 40.
Yes.
Some similar matter yet to be transferred from Honorable Arunachal Ganj to this Honorable Principal Seat. So so maybe taken together and maybe listed after summer vacation.
Why?
Some similar matter yet to be transferred from.
Has to be transferred.
Yes.
So if we decide this matter, that it will cover those cases.
And in this matter, Lordship, we have not received the brief yet. And
You have not received the brief from whom?
from the previous council.
Who are you?
I'm in the item number 38, I am respondent number 3. And in 39 and 40, I am.
Have you taken the consent quiz for the petitioners?
Lordship, yes, Lordship.
Where are the petitioners? Who are they?
PK Tiwari sir is the,
Where is he? You bring one of his juniors and then we'll adjourn.
Lordship.
Make the Lordship. Lordship, I'm praying for listing of this matter. It was listed on motion column, my lord, and after the whole agency is, my lord, is a poor man, my lord. His house has, the finance of his house has been stopped, my lord, the installment, my lord. It is half constructed, my lord, as routine.
It's a pending matter.
Pending matter.
You go to
Next
the
week,
registry.
my lord, next week, my
Go
lord.
to the registry. Next.
Yeah, please, Lordship. In this case, my lord, husband of the petition, in this case, my lord, the husband of the petitioner died in the road accident, my lord, prior to the recent notification, my lord. Well, yes, sir, information, my lord, verification.
When did
is
he
not-
die? When did he die?
My lord, in the year 2008, my lord, at least 11 year Lordship will kindly say.
2008.
Yes, my lord.
And then you have, when
Yes,
did
sir.
you apply for?
That is, my lord,
You're not even ready with the facts.
yes, my lord, earlier, one repetition.
When
was
did you apply?
My lord, 14 to 2020, my lord,
21,
20,
20,
Yes, my
after 12 years.
after 12 years, my lord. Earlier, writ petition was filed, my lord, that was withdrawn, my lord, due to the discussion of, my lord, a delay, my lord. Delay on it. In that case, your lordship will connect, see at page 28, my lord,
Yes,
28.
yes. So what is the reason for the delay?
My lord, I have elaborated, my lord, at paragraph number 7, page number 6, my lord.
Yes, Mr.
Lordship, the ground which was lordship regarding the delay part lordship. That ground lordship.
We came to know the knowledge anyway. Now let it be decided by the deputy commissioner. Who is the authority? Deputy commissioner. Let it be decided whether, and it will be governed by the old notification or the new notification.
Lordship, as per the notification, accident occurred in 2008, Lordship. But
There is no 2008, there is a 2007, I think,
Or 23 at page.
Page?
At page 23.
23. 23 is the 2007.
Yes, my lord. That is the earlier notification, my lord.
I don't know. And according to you, the petitioner will be governed by which notification?
By the earlier notification, that the petitioner has not got the benefit, my lord, so that. recent
So
notification may be-
according, so
may
so
be
the,
extended, my
huh?
lord. Recent notification may be extended, my lord, to the.
Lordship,
How can it be extended? To me, how can it be extended?
Yes,
Please read your page 25.
yes, my lord. Yes, the lordship pleases, my lord.
Not pleases, as per what is provided here.
My lord,
Are you covered by the page 25?
my lord, 23, yeah.
Then, right. Heard, Mr.
W. Rahman.
W. Raman, learned counsel for the petitioner. And Mr. K. Gogoi, learned counsel for the
2, 3, 4, and 5.
respondents number
2, 3, 4, and 5.
2, 3, 4, and 5. Who appears for 1? Ms. G. Hazarika appears for respond number 1. The matter pertains to the claim of the petitioner for payment of ex gratia grant of rupees 1 lakh in terms of the notification dated 24, notification number RR full stop 86/2005/22 dated 24/4/2007 issued by the Government of Assam, Revenue and Disaster Management Department, Relief and Rehabilitation Branch. The petitioner's counsel submits that the petitioner's husband, Rahim Badshah, RAHIM died on 14/11/2008 in a road traffic accident, pursuant to which Barpeta Police Station case number 893/2008 was registered under sections 279/338/304(a/427 IPC. Full stop. The petitioner's counsel submits that the petitioner has also enclosed the next of kin certificate showing the petitioner to be the wife of the deceased. Full stop. Next of kin certificate issued by the Office of the Deputy Commissioner, Barpeta District. Next of kin certificate dated 31/8/22. 31. Issued by the Office of the Deputy Commissioner, Barpeta District, showing that the petitioner is the wife of the deceased. The petitioner's counsel submits that the petitioner would be entitled to the payment of ex gratia grant of rupees 1 lakh as provided in the notification dated 24/4/2007 and not the notification dated 15/11/2014, as the notification dated 15/11/2014 states that the rates in-
Second paragraph, Lordship, last 2 lines, Lordship.
says that incidents occurring prior to 15/11/2014 would be governed by the OM/notifications relevant for the period concerned.
Lordship,
Full stop.
Lordship.
Next. The petitioner's counsel further submits that the delay in filing the present writ petitions was due to the fact that the petitioner did not know about the ex gratia grant available, and the petitioner came to know about the same only after the passing of judgment dated 4/5/2019 in Gunalata Das and others versus State of Assam and others reported in 2019 for GLT 17. That is at page 7. It is there. Full stop. Next paragraph. Here, the Petitioners Council thus prays that a direction may be issued to the Deputy Commissioner, who is to the Deputy Commissioner,
Deputy Commissioner Borpeta.
the Deputy Commissioner, Barpeta District, to examine the petitioner's where is your application?
My lord, at page 22, my lord.
22. The petitioner's prayer for financial, for grant of ex gratia grant of rupees 1 lakh in terms of the notification dated 24/4/2007. First up, Mr. K. Gogoi, the learned. Now, the counsels for the respondents submit that they have no objection to the prayer made by the petitioner's counsel. Correct? First up. In view of the consent of the parties, the Deputy Commissioner Barpeta District is to examine the claim of the petitioner for grant of ex gratia grant of rupees 1 lakh in terms of the notification dated 24/4/2007 and the petitioner's representation dated 14/2/2020. First up, in the event it is found that the petitioner is entitled to the same, necessary sanction should be provided by the necessary sanction for payment of the payment of the ex gratia grant should be provided by the respondent number 1.
My lord may also indicate one thing because the incident was occurred in 2018 also. Whether that particular incident was occurred in a public place or not.
Huh?
Whether that particular incident was occurred in a public place or not.
Accident.
Not accident.
Full stop. It is needless to add that the Deputy Commissioner Barpeta District will no, these things, it does not say public place.
Lords,
It does not say public place.
lords,
Cut that.
no, 2000. I don't know. In 2014 notification, it is specifically.
So
2007 there was-
2014 is 2 lakhs.
Lord.
He's not claiming because of that.
2014.
Then cut that, it is needless, huh? The writ petition, the entire exercise should be concluded within a period of 2 months from the date of receipt of a certified copy of this order.
3 months. Lord.
3 months, okay, 3 months. The writ petitions accordingly disposed of.
Apology.
Objection.
May I please? Oh, that corporate.
Wait, your lordship, kindly the matter will be passable for a timing, my lord. He is on legs, my lord. SK Talukdar, my lord, Corporation Department.
I don't think there are any other long matters.
Lordship, after the motion.
As soon as they come, we can go.
Obliged, my lord.
No, 12, 13, 14, 15, 17, 18, they're all same. Correct. It's all with regard to 130A only. So after some time, we are waiting for Mr. Tal. You're going to be arguing this matter.
Yes, your lordship. For item number 14, your lordship.
Okay, then Mr. UK could have been here. We'll take it as soon as Mr. SK Talukdar comes. Okay, because we'll take it at one go.
Gotcha.
I think that 12.
14, lordship.
My lord, item number 14 is.
Lordship, the issue is different in this matter.
Yeah.
14.
Okay, item 14, the issue is different. I thought it was all the same.
It's regards to.
It's different, my lord. It's a cooperative society matter.
So
No, there is-
the item 13 is also a cooperative society matter. So what is the matter in
It's a Binapani Cooperative Society.
what?
Binapani Cooperative Society, my lord.
So
My lord, kindly come to the page 15.
give me item 14. 13. page 15,
50, my lord, 50.
50.
My lord, this is a decision of managing committee of the state society, my lord. For regarding the transfer of share of nominee of share of late Kamala Devi in favor of the petitioner. My lord, this decision was taken on the basis of a written application by the late Kamala Devi. My lord, there is a rule in the Assam Cooperative Societies Act. This rule says that, Rule 20, my lord, that a member.
Just
of the
a minute,
cooperative
just a
society-
minute. No, what is the facts of the case? Just tell me the facts of the case.
Uh,
Not making sense. Your, your, your synopsis itself is like a repetition. Yes,
My
very
lord,
long.
my lord, in the AGM of the state society.
What is the issue about seniority, promotion, shares, what?
My lord, shares. the
Shares. So what
shares.
has happened to the share? Who shares?
It is the share of late Kamala Devi.
So what has happened? That has been transferred to whom?
Transferred to his, her elder son, that is okay, our petitioner, my lord,
Petitioner is the son of the late
Kamala Devi.
Kamala Devi.
But my lord, the AGM,
Huh.
that state society in General Assembly, they rejected that application and transferred. that-
Rejected the application for transfer to the petitioner.
Yes, my lord.
And
Then they transferred such shares to the respondent number 9.
who is he?
He is the younger son of late Kamala Devi, my lord.
Oh, that means your brother,
Yes, my
your
lord.
brother. So you are aggrieved with that.
Yes, my lord.
On what basis did they transfer it to respondent number 9?
My lord, according to them, the application made by the Kamala Devi, in that, she addressed that society as a Binapani Samabay Samiti. But according to them, the name of the Samabay Samiti is Binapani Cooperative Stores Limited. On that basis, they rejected the application, my lord. On the,
Whose application did they reject?
they rejected the application of late Kamala Devi.
They rejected the application of late Kamala Devi to transfer her share to you.
Yes, my lord.
And is that an appealable order?
Appealable order. My lord, this decision is actually itself a appealable decision, my lord.
Is it appeal? Then you go and appeal.
Under section 34 of,
Then you go in appeal. When was it transferred?
my lord, the petitioner filed a writ petition in this honorable court, my lord. Then, this.
Where is
court-
that? Where is the order of this court?
It is, in my lord, Annexure J, in the page 108.
108 petitioner is Dilip Barwa.
Yes, my lord.
Then out here the petitioner is Mohizur Rahman.
My lord, our petitioner is.
Dilip Barwa, item 14. Okay.
Yes, my lord.
Item 14, yes.
My lord, here the honorable court directed him to file a representation before the respondent number 2, that is the Register of Assam Cooperative Society. Then, my lord, respondent number.
Just a minute. Yes, so what has happened? So did
My
the registrar dispose of the,
No, my lord, respondent number 2, that is Registrar of Cooperative Society, he empowers the respondent number 3, who is the Zonal Joint Registrar of Cooperative Society, to make an inquiry, my lord. Then there is an order of respondent number 3 in page 112. Where, my lord, he confirmed that the resolution taken in AGM dated 30/5/2022 regarding the transfer of nominee is not proper and hereby disapproved.
so it is in your favor.
Yes, my lord, it is.
So then what has happened?
Then, my lord, also the respondent number 3 directed the society to hold a special general meeting. Then, my lord,
Respond number, respond number 3 directed where? Page?
Page 113, your lordship.
Page 113.
Operating
Yes,
portion
my
of the order, your lordship.
Yes, then what
then, my
happened?
lord, in that special general meeting,
Ah,
they again upheld that disapproved resolution of AGM dated 35, which was disapproved by the zonal, my lord.
okay. So let us see the AGM of that first AGM resolution,
Okay, my
page
lord. In page 56.
50.
And, my lord, in page 60.
That is page 50 here, is it?
My lord, AGM was.
Just a minute. As per the previous, I will call this,
But, my lord,
report
70
about the legal area. So this page 50 is in your favor,
No, my lord, kindly come to page 60,
60.
7 resolution.
Yes, what about it?
My lord, in last 3 line, my lord, the house resolves to consider Bipul Borua, who was appointed as an heir first, to be the heir of the share of late Kamala Devi. And grounds are, my lord, written above.
Just a minute. The house results. Okay, so this is then what is the difference between 50 and 60? 50 is a different meeting,
My lord.
is the
50
meeting of the executive body,
Yes, my lord.
and page 60 is the meeting of the,
Annual general meeting.
Huh?
Annual general meeting. of
AGM.
the- Yes, my lord.
So the executive body meeting minutes and the AGM meeting minutes are different.
Yes, my lord.
So this was set aside by the
Zonal, my lord.
zonal
Number 3.
respondent number 3. And now respondent number 3 at page 113, correct?
Yes,
Then
my
what
lord.
has happened?
Then, my lord, in 121, page number 121.
121. Yes.
My lord, in first 2 line, the house resolves to keep the decision made in the annual general meeting dated 35/2022 upheld. My lord, the order which was disapproved by the zonal, they upheld that order in their special general meeting, my lord.
And subsequently, your lordship, that particular special general meeting has been approved by the zonal joint registrar, your lordship. Yes, your
How can he do it? That means he's speaking in 2 voices. Where is the approval given by the
It
zonal?
was given on page number 131, annex M, your lordship.
1?
131, last page, your lordship.
Yes, my lord.
With reference to above,
Okay.
inform the approval of the minors.
So
of the-
this transfer of shares was done by prior to her death, is
Yes,
it?
my- No, my lord.
After her death?
After her death, your lordship.
After her death. Then who has made the application? But you said that Kamala Devi had made the application. Then can she make an application after her death?
My lord, Kamala Devi made the application on 28/10/2021.
Just a
Letter
minute. Application on
28/10/2021.
28/10/21.
Then, my lord, she died on 19 January 2022.
19. That's what I'm saying. So before her death, she made the application. You said no.
Yes, my lord, written application. done
Please
before-
try to understand the question. You're confusing the court.
Yes.
How can a dead person make an application? That's what I said. Okay. Yes. So what have you got to say?
Lordship, otherwise there is a question of facts involved, because if your
No,
lordship-
whatever it is. When the zonal registrar has already taken a decision.
Yes. But your lordship, that has been sent back to the board of directors to decide afresh. And they have taken a decision on the second special general meeting that,
To decide afresh.
yes, your lordship, if your lordship kindly come to page 113.
Yes.
Decision of Journal Joint Register of Cooperative Societies. Hence, in view of the above resolution taken in the AGM dated so and so regarding the transfer of nominee is not proper. and
Anyway, we'll issue notice.
Lordship.
Heard Miss
J. Bezora,
J. Besh Barwa,
Bezora, my lord.
learned counsel for the petitioner, who submits that the petitioner's mother,
My lord,
who
my lord, my prayer is that please curtail the voting right of respondent number 9 in next general meeting, my lord.
when is the general meeting held? When to be held?
My lord, I don't aware about the date, but
Okay, we'll see. What was it?
Ms. J. Bes Barwa, counsel for the petitioner who submitted the petitioner's mother.
Petitioner's mother, Kamala Devi, was a shareholder of the stores in the Bina Pani Cooperative Stores Limited. Full stop. The petitioner's mother submitted an application on 28/10/2021 to transfer her shares to the petitioner. The petitioner's mother expired on 19/1/22. Full stop. The meeting of the executive body of the Bina Pani Cooperative Stores Limited on 27/11/2021 resolved to include the name and particulars of the petitioner as the legal heir of the late Kamala Devi in respect of the shares of the late Kamala Devi. Kamala Devi?
Kamala Devi.
Kamala Devi. Full stop. However, in the AGM held on
35,022.
30
Yes, ma'am.
35/22. The House resolved to consider the respondent number 9, who is the elder or younger? Who is the younger brother of the petitioner, to be the heir of the share of the late Kamala Devi. Being agreed, the petitioner filed WPC number 4603/22. This court disposed of WPC 4603/22 by order dated 18/7/22 by giving liberty to the petitioner to file an appropriate representation before the Registrar of Cooperative Societies, respondent number 2. The respondent number 2 thereafter delegated the consequent to the above, the petitioner submitted a representation before the respondent number 2. The respondent number 2 thereafter directed the Zonal Joint Registrar of Cooperative Societies, respondent number 3, to examine the matter and take a decision on the same. Accordingly, the respondent number 3 examined the matter and by order dated 28/10/2022 held that the resolution taken in the AGM dated 30/05/2022 regarding the transfer of share of the late Kamala Devi to the respondent number 9 was disapproved,
Improper and hereby disapproved.
was found to be, where does it say improper?
Improper, my lord, and whereby disapproved.
Where does it say?
In my lord, page number
It was improper, was not proper, was not, it was found to be improper
11.
and was disapproved. Full stop. The respondent number 3 in the order dated 28/10/22 thereafter directed the Board of Directors of the Binapani Cooperative House Limited to resolve the matter of transfer of the shares by holding a special general meeting under section 33 with clear justification following all the provisions of the ACS Act 2007 and bylaws of the society. Full stop. Thereafter, the special general meeting was held on 30/11/22, wherein it was resolved that the decision made, wherein it upheld the decision made in the AGM dated 30/5/2022. That's all. The decision, the decision taken in the special general meeting has subsequently been approved
Respondent number 4.
by the respondent number
4.
4. Issue notice and by respondent number 4, that is the District Deputy Registrar of Cooperative Societies, Sonitpur.
My lord, he
Oh.
approved that notice on the back of the respondent number 2 and 3 without perusing their order, my lord.
On the back of the approval given by the respondent number 2 and 3. Issue notice returnable in 3 weeks. Mr. G. Bodolo accept notice on behalf of respondents number
1 to 5.
1 to 5. Petitioner will take steps for service of notice upon the, who is for 6? Mr. Huh?
R. Talukdar for
R. Talukdar appears for respondent number 6. Petitioner takes steps for service of notice upon the respondent number 7, 8 and 9 by a registered post with AD within 2 days. List the matter after 3 weeks.
Extra copies may be furnished. Extra copies may be furnished.
Extra copies be furnished.
Okay, my lord.
Then
Obliged.
to the council for the respondents. Extra copies of the writ petition. Huh?
Okay, obliged, my lord.
Lordship, in this case, I have received oral instructions, Lordship. Lordship, as per the department's record, in form number 26A, the tax deducted at source by the
Huh?
the tax deducted at source by the employer of the petitioner did not reflected, Lordship,
The tax deducted at source from the
from the account of the petitioner.
from the account of the petitioner,
That is not reflected in form 26A, AS, Lordship.
that is not reflected in,
Yes,
so then what to do?
Is
Then
the responsibility of the employer to deduct the tax from the salary of the petitioner and deposit the,
so it has to be reflected.
then it is to be reflected. And Lordship, in the petition, High Court has given on certificate. Lordship, that is at page 47. 47. Page 47, madam. Page 47.
Yes.
Lordship, this is to certify that a sum of rupees 77,301 has been deducted and deposit in the central government account through district treasury office by government bill number so and so. on behalf of so-and-so, on account of DDS from his areaship paid so-and-so. Lordship, Restaurant may be directed to provide the copy of the challan so we can verify whether it has been properly deposited in the account.
This is of which year?
Yes, Lordship, assessment year.
8, 9, 9, 10.
Huh?
2008, 9, 9, 10.
Will it be available?
My lord.
It must be available, Lordship, because Lordship in 26, form 26 AS is not reflected. We have the cost check also from all the departments. And similarly, Lordship, Lokayukta, Lordship, he has given a Lordship page 57.
Yes, sir, ma'am.
In inviting a reference to the subject cited above, I am directed to send herewith the photocopy of Form 16 for the financial year 2011-12 assessment year.
So the tax deducted at source from 2008-9 to 14,
Yes, sir.
that is not reflected in the
Form 26 AS.
Form 26A.
In AS.
Yes.
Huh?
Yes, madam.
AS.
26 AS, madam.
Form 26 AS.
Yes,
Now, but this 47 says it has been paid,
my lord.
page 47.
My lord.
Now, so you want proof of that.
Yes, sir.
Now, how do we get proof of that?
Lordship,
From the registry.
And the register of the Lokayukta, my lord.
So is the High Court a party?
Yes, sir.
Yes, madam.
Okay, where, yes, who is appearing for the High Court? Madam, can you provide proof of your document at page 47? No. So what do? We dispose of this petition or we keep it pending?
My lord, we keep it pending until they.
Let them produce the proof,
Yes,
correct?
not- Interim order is operating, my lord. So
Huh?
interim order is operating.
Okay. Heard, Mr.
M. Sahewala.
M. Sayawala, learned counsel for the petitioner. Mr. S.C. Kyal, appearing for the
Respondent number 2, 3, and 4.
2, 3, and 4. Submits that the TDS amount deducted at source by the employer is not reflected in Form 26 AS.
Yes.
Form 26 AS. Full stop. As such, the employer, that is the respondent number
5 and 6, madam.
5 and 6, should produce proof of the same. Full stop. Mr. M. Sahewal, no, Miss, yes, so yeah. P. Sharma appearing for Mr. T. J. Mahanta, learned standing counsel, learned, huh? Learned standing counsel for the respondent number 5 and 6. 5 for the for respondent number 5. Will produce proof of the TDS,
Certificate.
huh?
TDS certificate.
TDS certificate.
The proof of the deposit, because TDS has been.
No, the proof of the proof of deposit of the TDS.
Yes.
Keeping in view the certificate dated 18/11 to 2020 issued by the Registrar General, which is at page 47 of the writ petition. List the matter.
My lord, notice may go to respondent number 6, my lord.
Oh.
I don't think there is a standing counsel for Lokayukta. Respondent
Is it
number-
required at this stage? Once he brings that,
My
then
lord,
the-
because I was also an employer of the Lokayukta, my lord.
okay, you are
High Court as well as Lokayukta.
Lokayukta when?
My lord, 2012, 13, 13, 14.
Okay, so Lokayukta is also
My
necessary.
lord, so notice may go to.
Right, issue notice. Heard also, huh? Then you say issue notice. Returnable in 4 weeks. Mr. S.C. Kayal accept notice on behalf respondents number 2 to 4. And who is for the Finance Department, Finance Ministry, Union of India?
What's if I can represent?
Okay, Mr. S.C. Kayal accept notice on behalf respondents number 1 to 4. Miss, your name? P. Sharma accepts notice on behalf respondent number 5. And what about as a Metro Treasury Office?
The 7 and 8, my lord, the government.
How can it be Treasury Officer, Dispur and Kamrup Metro, who?
Actually, they are not necessary party.
Okay, right. Then you say issue notice to the response number 1 to 6 only, huh?
No.
Petitioner takes steps for service of notice upon the response number 6 by registered proprietary within 2 days. Then you write whatever I said. Then you write what I said earlier, okay? Okay, then list the matter after 4 weeks. Interim order to continue till the next date. Interim order to continue till final disposal of the case.
On the last occasion.
Yeah, on the last of it, my lord,
Last
I
to
took,
TST.
time my lord, for obtaining instruct, my lord. Accordingly, I got the instruct, my lord.
My lord, if I may place the fact, your lordship, my lord, as part of the provisions of the Provident Fund Act, if
Ah.
a T estate,
If,
if a T estate falls default in payment of the Provident Fund of the laborers,
yes,
then the concerned authorities has the power to attach the tea garden.
attach the tea
Attach the
estate,
tea garden. In this
attach the
tea garden.
tea garden.
Tea garden, factory, everything. And they can run the business through appointing a manager, or they can put it to auction sale. The subject matter.
Which authority will attach it?
My lord, this is the respondent number 2, my lord. Respondent number 2. They have a recovery officer also, my lord, as part of.
What is the, who is that thing?
My lord, the recovery officer, Assam Tea Employees Provident Fund Organization, my lord.
Yes.
My lord, respondent number.
Respondent number 2 is the secretary come PF commissioner.
PF commissioner, and 3 will be the, madam, 3 is the concerned respondent.
Yes, then
What has happened, my lord, the subject matter before your lordship is regarding the tender, my lord, e-auction sale. The petitioner,
because of non-deposit of the provident fund,
lordship,
it was attached.
it was attached.
Ah,
Attached, then it was put to sale by auction.
ah.
If your lordship peruses, I am just taking your lordship to one document, my lord. Page number 28, my lord. Just take a moment.
Yes,
Page 28 is the notice of attachment, my lord.
yes.
Then, my lord, page.
What is the date? 5/12.
It was attached on 5/12/2017, my lord.
Yes,
Now, my lord, page 29,
yes.
Annexure C, this is the, my lord, sale by e-auction notice, my lord. 6/12/2022, my lord.
Yes.
Now, if you're.
What is the date?
My lord, it is 6/12/2022.
Then when was it actually auctioned?
Auction took place on 14th, lordship, 14th of March 2023. If your,
14 March 2023 auction.
if your lordship peruses Annexure D, page 31, my lord,
Yes,
then in page 31 is the, my lord, result sheet. Is the result, auction result, my lord.
auction result.
Auction
Dated,
result. If your lordship peruses, then two parties participated, my lord,
yes.
and the petitioner turned out to be the highest bidder.
Petitioner is this Snowflake.
Yes, my lord.
Snowfall.
Snowfall Agro Products Private
Snowfall.
Limited is the highest bidder, my lord.
Yes,
Thereafter, my lord, what happened? Annexure page 32, my lord. The authorities informed the petitioner that his bid has been evaluated as the highest bid.
so it deposit 25%.
Deposit 25, lordship. So he deposited through 6, my lord, on 17/3. He deposited checks, my lord.
Deposited, how much? 25%.
25%, my lord, something 4 crores, my lord.
When did you deposit?
4 crores 16 lakhs,
When?
on
When?
17th, my lord.
17?
17th of March, my lord.
Yes,
Through checks, my lord. But on the same date, my lord,
yes,
Annexure G, my lord, on the same date, when he after depositing the checks, my lord,
yes.
he
Page
receives a my lord,
33,
Annexure G, my lord.
G,
He receives a communication, my lord.
page 30, which page is it?
Page 41, my lord. I follow. Page 41, Annexure G, my lord.
Yes,
On the same date, he receives a communication, my lord. It reads as such, my lord. With reference to the above, this is to inform you.
yes,
With reference to the above, this is to inform you that the e-auction process for the sale of properties of Fatemabad Tea Estate is kept on hold due to technical ground. First, they say that it is a technical ground for which it is kept on hold.
Yes.
And thereafter, they issued an impugn letter, my lord, page 43. On 4/4/2023, my lord. 4th of
Page 43.
43, my lord, is the impugn letter.
Dated
Dated 4th of April 2023, my lord, is the impugn letter. My lord.
4/23, yes.
In this letter, they say, my lord, may I just read out, my lord? With reference to the above, I am to inform you that on scrutiny of your bid and other relevant documents, it is found that you have failed to comply with the terms and conditions envisaged in clause 14 of the e-auction notice as on the date of e-auction, and as such, your bid for sale of properties of Fatemabad Tea Estate held on 14/3 has been treated as cancelled on aforesaid ground. Now, my lord, may I just take your lordship to that clause 14 of the notice,
Yes.
my lord? It is in page 29, my lord.
Yes,
At the bottom, my lord, just 1 point below bottom.
yes.
The intending purchaser oblique bidder shall not be defaulter of any sort to any provident fund organization, and further there shall not be any criminal case pending against the intending purchaser oblique bidder or against his firm, company, declaration to be furnished. Now, my lord, in this regard, we have submitted a representation. What exactly has happened when the tea garden was attached by the authorities? My lord, they came into a private arrangement with one of the directors of the petitioner company.
No, no, no. Who got into a private arrangement?
My lord, with the, that is permissible under the act itself. I can show it, my lord. They executed a registered deed of agreement that so and so will run the property and he will facilitate the recovery of the tea estate outstanding PF. My
No,
lord,
no, who are you otherwise
I am the
anyway?
petitioner, my lord.
You're the petitioner.
But
That
petition-
much I know.
Yes, lord.
But you entered into an agreement
No, my lord, one of the directors of the petitioner company in.
or
his-
one of the directors of the petitioner
in
company.
his independent capacity.
Okay.
Now, my point in this.
He entered into an agreement to what effect?
That he will run the affairs of the tea estate and facilitate the recovery of the PF account money and deposit it accordingly. Now, there of the allegation that since this particular director has defaulted, your bid cannot be considered. Now, my lord, main plea in the writ petition is that the director,
So the director of your company
my company, but in his
entered into an agreement with
the
that other company.
recovery officer, my lord, with the
Yes,
recovery-
with that company who was running the tea garden
Your lordship.
for recovery of the.
No, not with the company, with the recovery officer himself. Because post attachment, he cannot do any arrangement with the earlier company. Earlier company.
No,
is
but then
nobody
this agreement was made prior to the attachment.
No, after attachment, lordship.
It was made prior to the after
After,
attachment,
be that as it may, my lord, what has happened?
but prior to the auction notice.
Or auction notice, my lord. Now, what has happened, my lord? My plea in the writ petition is that the person being having entered into an agreement in his individual capacity, then these acts cannot bind the rights of the petitioner to.
But you aren't, isn't the director a trustee of a company?
My lord,
Isn't the director a trustee of a company?
my lord, he is one of the directors, but the company itself being an artificial legal person, my lord, it can have its own rights. And it on the book of accounts of the, my lord, PF, my lord, he is not, even then, my lord, even then, thereafter a representation was placed where it was shown, even the director has paid in excess by 60 lakhs, my lord. At this stage, my lord, my prayer is that since they have not settled the tea garden with any other bidder, my lord, let notice go and let them pass a speaking order on this representation, my lord, because he has given the entire account.
Which representation?
My lord, yes, their representation is at page, let's say last annexer I, my lord,
Page 44.
page 44, my lord. On 8/4/2023, as representation has been submitted to the recovery officer, showing that actually in excess of 60 lakhs has been paid, my lord.
So,
Let them deal with them.
so you must have recovered some amount.
Lordship,
Anyway, leaving that aside. Yes,
I am repeating my lord. But actually, one of the director, my lord. In his personal, now he said that on his personal capacity, he entered into an agreement, my lord. Or that he will be liable to be, they declared to be a defaulter, my lord. Once one of the director, he
correct.
made a default, my lord. As per the agreement, you are supposed to deposit the entire by areas for PF contribution amounting to rupees 3 crores odd, my lord. That amount he has not, till now he has not deposited. 3 crores of it. Areas provision.
He had made an agreement with whom actually? This
With the
director?
recovery officer.
Huh?
With the recovery officer, response number 3, my lord.
But why have you made an agreement?
Well, that is permissible under the act, my lord. It can go for private settlement also to facilitate the recovery. Actually, what happens, my lord, when the CS.
Anyway, he wants his representation to be considered. Let it be considered. We'll dispose of this repetition that way.
But till that, they will not settle it. Till the date of disposal, they will.
They are running a garden, my lord.
Right. Heard Mr. G. Rahul, learned counsel for the petitioner. And Mr. N.C. Das, learned senior counsel for the respondents number 2 and 3.
2 and 3, Lord.
2 and 3. Mr. R. Talukdar appears for respondent number. Respondent number. The petitioner is aggrieved with the impugned letter dated 4/4/2023, wherein the petitioner's bid in the e-auction of the Fatemabad Tea Garden has not been allowed to be completed. No, the bid in the e-auction of the Fatemabad Tea Garden was accepted, but the entire sale transaction was not allowed to be completed, on the ground that the petitioner did not comply with the terms and conditions envisaged in clause Roman 14 of the e-auction notice dated 6/12/22. Correct? The case of the petitioner is that due to non-deposit of the provident fund of the employees of the said tea garden, the said tea garden was attached on 5/12/2017 by the respondent number
3.
three. Thereafter, in person to an e-auction sale notice dated 6/12/2022 in respect of Fatemabad Tea Garden, an auction was held on 14/3/2023. The petitioner was found to have tendered the highest bid amount in terms of the auction result published by the respondent number
3 in the website. madam.
3
In the official website.
in the official website of the respondent number
3, madam.
3. Next para. The respondent number 3 thereafter issued a letter dated 15/3/2023 to the director of the petitioner company stating that as the petitioner's as the petitioner's quoted price was the highest in the e-auction, he was advised to deposit 25% of the quoted amount, that is rupees 4,16,29,250. The petitioner thereafter deposited the said 25% on 17/3/23 by a check. Next para. The Respondent number 3 thereafter wrote a letter to the petitioner stating that the e-auction process for the sale of the properties of the Fatemabad Tea Estate was kept on hold due to technical ground. And was accordingly advised not to act accordingly. And was accordingly advised not to deposit 25% of the quoted amount. Acha. What's up? Then you write actually. The next paragraph, the petitioner's counsel submits. So the earlier sentence will go. The petitioner's counsel submits that the petitioner had, however, submitted 25% of the quoted amount in terms of the no. Had however submitted the 25% in terms of the letter of the respondent number 3, letter dated 15/3/2023, issued by the respondent number 3. Write a check. Full stop. Next paragraph. The respondent number 3 thereafter wrote a letter. Wrote the impugned letter, thereafter wrote the impugned letter dated 4/4/2023 to the petitioner, stating that on scrutiny of his bid and other relevant documents, it was found that the petitioner had failed to comply with the terms and conditions envisaged in clause 14 of the e-auction notice. And as such, the bid of the petitioner was treated as cancelled on the aforesaid ground. Full stop. Next paragraph. The petitioner's counsel submits that this writ petition may be disposed of with a direction to the respondent number 3 to no, before that you write, the petitioner submits that the petitioner thereafter submitted a representation dated 8/4/2023 for recalling the impugned order dated 4/4/2023. Full stop. However, no action has been taken by the respondent number 3 against the petitioner's representation. Full stop. Then you say that, the petitioner's counsel submits that this petition can be disposed of if a direction is issued to the respondent number 3 to take a decision on the petitioner's representation dated 8/4/2023 within a specified time period. And until a decision is taken, the sale of the property in question should not be done against any other party. Should not be done with any other party. Full stop. Mr. N.C. Das, the learned senior counsel for the respondent number 2 and 3, submits that he has got no objection to the prayer made by the petitioner's counsel. In view of the consent of the parties, the respondent number 3 is directed to examine and then take a decision on the petitioner's representation dated 8/4/2023. Within a, should I give a time period? No need.
Within a period of
Within a period of 1 month from today. From today, full stop. Till a decision is taken by the respondent number 3, the respondent authority should not finalize the auction sale of the Fatemabad Tea Estate in favor of any other party.
in disposal of the money.
Till this, I said till disposal. The writ petitions accordingly disposed of.
May please, your lordship.
Workshop bills.
Lordship. Lordship, the amount is admitted at page 25, lordship. So this is issued by the executive.
I do not
engineer
know.
and the accounts officer.
Yes, what to do, madam? Issue
Lordship,
notice.
for some time to verify. and
We
get
verify
those.
it. Okay, right.
So your lordship, perhaps finance is a necessary part.
Finance will not be a necessary party. lordship.
Huh?
Finance is not a necessary party. in this case.
Actually, you should,
Accounts officer of the department. They are-
actually, you should, make finance a part, it becomes easier. And then for the department also. Because one thing, the departments usually don't have money. Because it's all under different heads.
Lordship.
Okay. So now when we pass an order, then they have got to take money from the finance department. So if they are a party, it becomes easier.
Lordship, then I may be permitted to make finance a party by hand, lordship.
Correct. Third, Mr.
M. Das.
M. Das, learned counsel for the petitioner who submits that the petitioner is running a workshop
Lordship.
and that the respondents number,
Respondents
respondent numbers
6.
2 to
Six.
6 have not paid the outstanding dues of the petitioner amounting to rupees 4,11,153 for repairing their vehicles. Full stop. He submits that the said amount is an admitted amount as can be seen from the,
Annexure 4, page 25.
as can be seen from the statement of outstanding liabilities made by the respondent number,
Respondent number 2 and respondent number 3.
respondent number 2 and respondent number 6. No, respondent number 2 is respondent number 6. Full stop. The petitioner's council has also made an oral prayer to implead the secretary, commissioner secretary,
Commissioner Secretary.
commissioner secretary to the government of Assam Finance Department. Full stop. The prayer of the petitioner's council is allowed. The registry to make necessary correction to the same. Full stop. Issue notice,
Yes,
issue notice returnable in
3 weeks.
3 weeks. Miss
M. Kalita, my lord.
M. Kalita accept notice on behalf of
All the respondents. Lordship.
finance also.
No, 1 to
So
6. they can
finance
take.
is not made a party.
We have made a party just now,
Okay. 1 to 6.
1 to 6. While Mr.
Each move आपको find.
H. Barrow accept notice on their respondent number 7. This is a matter after 4 weeks to enable the respondents to obtain instructions with regard to the above. Extra copies of the writ petition be provided to the councils for the respondents.
Can I be permitted to make the correction by hand?
No, let the registry do the.
All right, lordship.
Or we'll tell them to do it. Okay, the petitioner's council, I said, don't say registry then, cut that registry part. The petitioner's council is allowed to make necessary correction to the cost title by adding the respondent, the newly pleaded respondent number 7.
Lordship. All right.
In this matter, I am appearing on behalf of respondent number 2 and 3. My lord, we would like to file our affidavit. Let it come after 4 weeks.
What is this matter? I'm not understanding.
My lord, kindly see page 15, my lord.
15 years.
The title suit, this is order passed by this honorable court in
Yes.
title suit, so and so was filed by the petitioner against his own elder brother,
Yes,
claiming right title interest with a prayer for cancellation of 2 registered sale deed executed by his father in favor of the defendant. I,
defendant means the respondent.
yeah, I petitioner, petitioner herein was the defendant,
Was the defendant? Okay, was the defendant.
was the defendant. in favor of me, my father executed a gift deed. I took possession of the land and I applied for construction permission. Then they have filed challenge the gift deed.
Who has challenged?
One of the brother, that is the petitioner, respondent number 4 here in this case.
Okay.
Then injunction was refused. Civil
You challenge what? Challenge the property? Challenge the,
gift deed.
they challenge the gift deed.
Gift.
Huh.
Injunction was refused. Then civil suit was also, civil court was also dismissed the injunction petition, then came up before this honorable court. This honorable court also allowed the, upheld the order. Make construction at the own. cost
So the
and
gift
need.
deed has been, so the gift deed, now there's no challenge to the gift deed now.
Challenge to the gift deed, it suit is pending,
The suit is still pending.
still pending. Now, during pendency of the suit, injunction petition was filed, that was dismissed. Then up to this honorable court, that there was no injunction order. And kindly see
So
the-
you have constructed the building.
with the permission. Then
Okay.
when permission was granted after passing of this order by this honorable court, they again issued a notice for stop the construction.
Who issued a notice?
Municipal board.
Then,
Then municipal board, again I have challenged by way of writ petition before this honorable court. And this honorable court kindly see order at page 22.
yes, what did he say?
I can carry out the construction work. Then I have constructed. Now I want splitting up of the holding.
Into,
In-
in whose, in how? In your name and your son's name or what?
In my, yes, in my name.
In your name?
Yes.
Both will be in your name.
No, not both.
One will be in your name
The-
and
with-
one will be in,
Splitting up. That is earlier holding was in the name of father.
okay.
Then.
So you want, so you, how do you want it split up?
Because I have constructed a new.
Mr.
house.
Council,
Yeah.
supposing I have a cake.
Yeah.
I say that I want to split it up. I'm saying that I'll split it into two. One piece of cake, I'll take it. One piece of cake I'm giving to my, whoever I want to give. Now you want to split up your land.
Not.
Then you want to split up what?
Holding number.
Holding number.
Holding number
Holding number relates to what? Land
of the house.
of the house.
Of the
Okay, house.
House.
So you want to split that into whose names?
my name.
Both.
No, not both. Over which I have constructed
Okay.
on the basis of.
So you want to split the land where the house is constructed in your name and the other. I'm not getting you.
My lord, one land.
Maybe, look, maybe I'm the one ignorant here, most probably. So just clarify this aspect to me.
My lord,
You want to split the holding.
2 kathas of land,
Ah.
out of 1 bighas of land, 2 katha land has been gifted by my father to
Yes,
me.
okay. So there has
want
been no partition of the land. Is it?
Only
No,
2 katha.
so it is still in the name of your father.
Father died. Now it is in the name of all the legal heirs.
The entire land is in the name of all the
All
illegal.
the legal heirs.
But then you said,
Except this gifted land.
except this small portion of gifted land.
Gifted.
So this small portion of gifted land, you want it in your name.
Yes.
It's already in your, it's not in your name.
My lord, not with respect to land, with respect to holding
Municipal holding.
municipal. If holding is not given, my lord, I will not be able to occupy the house.
House.
That is why I have filed an application under the municipal.
But
act
then you want to say that you want to split the holding. That's
That
what you
means-
said.
by issuing separate holding in favor of him.
But that building you have constructed.
Yes. I have constructed.
I'm not getting, Mr. Datta, can you clarify? I have not understood.
Today I'm handicapped in the sense, my name has not been reflected, so I'm not ready with the brief also. Apart from that, my lord, I'm requiring some instructions from my party also.
I'm not trying, I don't understand. That holding is in, earlier, was there any holding?
Earlier, there was.
That
a
holding is in whose name?
In the name of my father.
The holding is in the name of your father. Which,
Possibly-
the holding can be, yes.
Possibly my learned friend want to say, earlier it was, the holding number was in the name of his father.
Ha,
Now, since the land has been gifted to him,
ha.
he is
Not entirely.
entitled to get another holding in his name. Possibly that is his case. Anyway, I can clarify it in the next.
I don't know, but then holding, I'm not getting you. I think.
My lord, until and unless the separate holding is given with respect to the property, with respect to the house over which I have constructed, I will not be able to occupy that house.
So how did your father get a holding? A holding has to be given in respect of a property, in respect of a building, or in
In
respect,
respect of building. that
in
is
respect of
property,
building.
Property. yes.
So when you constructed your building, did you construct it over your father's house or something?
No, no.
Then how?
Father given me out of the entire land, only 2 kathas of land gifted to me.
But you said,
Only 2 katha.
Mr. Manan, can you explain? I'm not getting. Can you?
What he's trying to say is that
Yes,
he has constructed a particular building
yes,
in about 2 kathas of land.
Yes.
2 kathas of land, which has been given on a gift by a gift deed by his father.
correct.
In that particular land, since he is already constructed the building, he wants to get into the building, so he needs a holding number.
Correct.
So that part I am also very clear.
Ah.
But since the other part of the land, the whole land.
But he says that it is his father's holding.
No, no,
No.
most probably he is saying that the whole land was in the name of all the other brothers and sisters who are there. So
Father's
he-
initial.
In father's, then it went back after his father's death, it went to the others. also.
Other.
So he wants that particular holding should be given in his name only. I don't think there is. such kind of
But
splitting
that
or- Splitting doesn't, I don't have anything to do here.
Ah.
It should be that.
No, but
his
I
holding
don't
number should be
understand.
given. He should be given in holding in the whole land.
So that portion which he wants in his name,
Yes.
it is in whose name right now?
It is in.
My name,
That is what
No,
he
no,
says. That is what he says. It is his name. I don't
it is my
understand.
name. Now that is understanding.
I'll clarify in the next.
Holding
Okay.
number,
Yes,
land is in my name.
that is.
Land is in their name.
Yes.
Holding number is not in his
Not,
name.
not in
So
my
he
name.
since his construction.
Land
he
of
has
the
the
2 kathas is in their name.
Yes.
He wants a holding number for the
Okay, but
building.
then that is what, that same,
Splitting
he
for
says
his
splitting,
premises.
then he says his father has a holding number.
His
That's what, and
holding number
he says
is-
that holding number can only be given with respect to a building. So that means he built his house over his father's house. Probably that, no.
No, he wants a holding number in his name. That's.
That's what I was reading it as, I couldn't make out what he was trying to
Yeah.
say.
The term splitting possibly, my lord, is a confusion.
That's why I've written out here also. What is this case? I have,
He confused with the word splitting. He should have said, I want a holding in my name, apart from the others who are there in the whole land. That is it.
Mr. Counsel, unless you can, communicate what you want to say very clearly.
Sorry, my lord.
No, there's nothing to be sorry about. Only thing is that unless you communicate, we are lost, You're the one who's going to help me up through the garden path. So if we both go in, unclear about facts, then we'll be heading up the wrong garden path. Anyway, I heard Mr.
SK Ghosh.
SK Ghosh, learned counsel for the petitioner. So what is the grievance? You have not been given the holding number. Huh?
Yes.
So you agreed with that?
Yeah.
Who submits that? He has not been provided the holding number for the building that he has constructed on 2 kathas of land gifted to him by his father. Full issue notice? No, he is accordingly praised for a direction to be issued to the
Respondent number 2 and 3.
respondent number 2 and 3.
Yes.
2 and 3. What do you mean? You want a reassessment? And you want a new holding number?
Yes.
That means there was an old holding number. So where is the old holding number? If you want a new holding number, that means there was an old holding number. What is that old holding number?
571
In whose name?
is in the name of my father.
Name of your father.
Father.
So that there was your father's building was there. earlier.
Other house. This are the other.
Other house.
Other.
That other house is within that 2 kathas of land.
No. One, nearing 1 bighas of land. Part,
That
part,
is-
part of land,
Part of the 2 kathas,
part of 1 bighas of land.
part of 1 bigha.
1 bighas.
So that is a different land. So that why should you want a new holding number? You should be given a holding number. That holding number is with regard to a different property.
Different property.
Then these words are, okay, I understand. You see, you're confusing the court by using the word new. Should just say that you should be given a holding number for your property, that's all. And then what is this reassessment? What do you want to reassess?
My lord, until and unless it is reassessed, the building which I have constructed, the municipality will not be assessed, able to tax.
Has it been assessed earlier?
No.
Then
You
if
will
there
not-
is, it has not been assessed earlier, where is the question of reassessment?
It should be assessment.
Then
It should be.
these are the words, which confuse us. You want a reassessment, it has never been assessed. So where's the question of reassessment? Then you want a new holding number, where there was no holding number given earlier. It was given to some other property. You should please understand the words that you are writing down in your petition. Now, when we give it to the government and the state authorities, the lawyers are not going to be there helping them read it. They're going to be confused. Much more than me. So what have I said?
You got any place for a direction to be issued to the respondent number 2 and 3?
2 and 3? Not 2 and 3. The 2 and 3 for assessing the newly constructed building and to give a holding number. Issue notice returnable in 4 weeks. Oh, 4 weeks. Mr. Who is accepting notice?
Mr. K. Upaman.
K. Upamanyu. Accept notice on behalf of response number
2 and
Huh?
2 and 3.
2 and 3. While Mr. R. Talukdar appears, accept notice on behalf of respondent number 1. Petitioner takes steps for service of notice upon the respondent number 4. This is the matter after 4 weeks.
Machu.
My lord, there is an interim there, my lord. Until and unless, only for occupation purpose. I
We'll
may be
see,
allowed
we'll
to
see.
occupy.
We'll see. We do not know. I can't make head or tail of it. Just 1 minute.
Each number is to 17 December. Correct, 3 weeks this. 20. The least the matter of তারপরে কোয়ার টাইম হচ্ছে আর 2 3 6 এত করে Total fix है। जा रहा है। না ওই যে
Huh? But they're not there, they're not there. They're there. Okay. No, they're not there. Where are they? They're not there. They're there. Yes. So which are the matters that are going to be decided? I think
My lord,
12, 13, 15,
13,
17, 18.
18.
Just put this
Hello?
off. Huh? Put this off. Put this 18.
My lord, before my lord, take my lord go further.
Huh?
On the last occasion, my lord, before that, the argument that was advanced was that the constitution provision is there, 5 years.
Yes, yes.
You can't go beyond that.
Ha, ha.
So the state, my lord, is bound, its hands are tied, so it has to go. I filed at that time, I did not have the, my lord, judgment.
Judgment.
I filed an additional affidavit wherein I brought the state action, wherein even in the 7th year, they had allowed. By exercising power under, naturally under
130.
130. Thereafter, my lord, I got the judgment of the Supreme Court, wherein, my lord, the very provision of the constitution was under challenge. Supreme Court interfered. It came from, my lord, Gujarat.
Yes,
The
Gujarat High Court.
Gujarat High Court, the Supreme Court interfered it and made it applicable only to multi-purpose, multi-state cooperative society. So that 5-year constitutional ban goes now, madam. It's not there.
Yes.
So the only thing that is before your lordship is the interpretation of 130. Now, my friend, if he has anything to say on the constitution, on the division bench, on the Supreme Court judgment, he may, my lord.
There's nothing much
Nothing
to
is
say, I
there
think,
left,
in the
my lord.
Supreme
No.
Court judgment.
If, my lord, I'll take only 5-10 minutes. My lord, if my lord comes to the
No, first of all,
lordship,
let us go to the fact,
lordship,
because at the end of the day, we'll have to see.
lordship,
Now, for item 12, that
lordship,
is WPC 1851,
lordship,
2023.
lordship.
When was the date of election?
My lord, the election was held on 19/8/2016,
19/8/2016.
lordship.
So 5 years would end on
21, my lord, 17/8/2021.
17 or 18/8?
Sorry, my lord, 18/8/2021.
18/8/2021. Now for WPC 1863/2023.
Lordship,
What is the date of election?
8/6/2017, my lord.
8/6/17.
1863,
So it will end on 7/6,
76,
2022.
lordship.
And for WPC 1980, correct?
1980, my lord, Uttam Kumar Roy, it is 24/9/2016.
980 of 2023. Yes, when was the election?
24/9/2016,
24/9/16.
lordship.
End on
24/9/2020.
23/9.
23/9/2021. Then,
And
my
then
lord,
WPC
2085,
2085,
2023, it is 19/7/2017,
19/7/17.
lordship.
So it will end on
18/7/22.
18/7/22.
Then, my lord, 2086,
23.
25/9/2016, It'll end on 24/9/2021.
So
No, my
they
lord.
are, so all of them are basically in their sixth year or seventh year?
Seventh year.
No, sixth year.
My lord, it would be sixth year would be for my lord, 1863
Uh-huh.
and 2085, my lord.
And for the others, all seventh.
All 7th year. So in this two cases, my lord, 1863 and 2085, even if that 1 year is taken, my lord, now, my lord, literally, they will be, my lord, still within the time.
Correct.
Now for the others,
No, just one thing.
lordship,
So section 130A,
lordship,
if I remember correctly, Mr. Talukdar had said that there was a notification made by the government that it will be for 1 year. Where is that?
That I will punish one.
Huh?
I will.
No, just so that, we keep those
Lordship.
things in mind
Yes,
because those are the main things. Then, of course, interpretation of 130A will have to be gone into that.
It is not that legible. But
Not that legible. Where only one copy you have got.
I will.
Huh?
I will get it Xerox.
When will you get it Xerox?
Doctor, take it up this one.
No, what about your friend? He also needs one.
Now.
Yeah, you have it Xerox. Okay, I think then you can start.
my lord, basically,
But my lord, before my learned senior starts, my lord, I have to say something on the constitutional aspect.
Yes, okay. Okay,
fine,
okay, let.
fine, let him.
Because that was that is how you started
Lordship.
your argument
Yes,
also.
in fact, my lord, since now this issue has come, lord, I need to address your lordship, my lord.
Huh?
Because eventually this issue will crop up, my lord.
Yes, yes.
Yes, since this, my lord, aspect has come, my lord. Now,
But he's not challenging the virus of 138. Let us be very clear.
correct, correct,
The only thing is now I think you've got to read down 138.
yes, correct.
Lordship.
Anna,
Lordship.
that's all I think.
That's all.
Yes. My lord, in fact, now pursuant to striking down of this chapter,
Yes,
so far as my lord, the state cooperative societies, my lord, is concerned.
yes.
Now, the question would be, my lord, what is the effect and consequence of the striking down? Whether, my lord, if there is any consequence, and if so, my lord, what? Now, my lord, this, or perhaps, my lord, issue will come because, in fact, when, my lord, the order judgment of the Supreme Court was passed, if your lordship takes up, my lord, the date, kindly take note of the date, my lord. That if your lordship takes up, my lord, the judgment,
Can you give me a highlighter? That yellowish golden color highlighter. You don't have, anyway, date is
my lord, the
20th July.
28th July, 2021.
Yes,
Now, if your lordship takes up 130A,
yes.
my lord, that was gazetted on 9th of June 21.
138A gazetted on 9th of June
9th of June
2021. 2021. Can you give me the gazette notification?
My lord, in the 58.
Huh?
58. Page 58 of that first repetition.
Page 15.
1851, 58. My lord. 1851, page 58.
Yes.
So this is the gazette notification, my lord, page 58.
Yes.
And my lord, giving it a retrospective effect from 25th of March 2020,
With effect from
25th of March 2020.
25/3/2020. Correct.
Now, my lord, the question is, my lord, in fact, I am not arguing that 130 is unconstitutional because
Ah.
it is the initiative of the state government when the
Yeah.
state legislature has brought about this amendment.
Yes.
Now, this question will, my lord, naturally arise.
Ah.
When, my lord, the constitutional mandate was in operation, my lord,
Ah.
at that point of time,
Ah.
my lord, this particular amendment was brought about. Because it was struck down in 28th of July, my lord,
Ah.
21.
Ah.
And it has been brought about on 28th of June, my lord.
Okay.
So
Now-
now, my lord, the question will arise.
So you're saying that 130 is not applicable?
I'm not saying that.
Then
What
what
I'm
is
trying
it?
to say, that, my lord, the interpretation of 130A, my lord, would be necessary to give it a constitutional validity and make it workable, my lord.
In terms of part 9B,
Not in times of part 9B, in the teeth, my lord, of this fact, that at that point of time.
It was
part 9B
5 years.
In, my lord, very much in operational, my lord.
Huh?
It was in operation, my lord.
but then it was found to be unconstitutional. So
Yes,
when
correct.
once it is
Well-
found to be unconstitutional, then how does it
No,
affect this?
what I'm trying to say, your lordship is deciding today, but this fact, my lord, when this, my lord, amendment was brought about,
Yes.
that has to be tested, my lord, on 9th of June.
No, no, no. No. Not when it has been declared unconstitutional. When an act is declared unconstitutional or any provision is declared unconstitutional, what does it mean?
My lord, had it been a case,
What does it mean?
but what I'm trying to say, that
Supposing something is done on the basis of an act or rule that is declared unconstitutional, can we say that the actions done on the basis of those unconstitutional law
yes,
is still valid?
my lord, that the effect of, my lord, repeal will not apply here. The act.
It is not repeal, mind you, this is not repeal.
Repeal, it is a
This is
striking down.
what is the effect of declaring a law unconstitutional?
Yes. My lord,
That means
here is a case, my lord.
Huh.
I'm trying to understand also,
Huh.
my lord, here is a case where the 130A, my lord, has to be brought into the statute book. In the teeth, my lord, of the mandate which was in operational, my lord. So what I'm trying to say, that to give a validity to 130 capital A, my lord, a harmonious construction, my lord, is called for.
No, you see, out here, 130A was made by amending the State Act. It had not been made on the basis of the constitutional provisions provided in Part 9B.
No.
So then
It
in
is
that
correct.
case, if the source of power was the State Act, we'll have to go through the State Act.
It is correct, my lord, but 130A involves 41(2) also, which is directly in conflict, my lord, with the constitutional provisions, my lord.
I don't know why you are arguing in
What
this
I'm-
line. You're the government, you are the one who
No,
brought
no,
in.
I'm trying to say,
34.
I'm not saying, my lord, that it is a, my lord, unconstitutional law. What I'm trying to say, that to make it workable and constitutionally valid, 130A, my lord, has to be, my lord, given a harmonious construction. That is what I'm trying to say.
Look, it's very simple. 130A in the face of Part 9B
Man.
is unconstitutional. But when Part 9B itself has been declared unconstitutional and 130A has been made on the basis of a State Act,
Right.
we'll have to see whether the State Act itself was unconstitutional. So if the State Act is not unconstitutional, because Part 9B has gone, and since it is provided in, I think, list 2
It's two and.
32. 32.
My lord, only I am asking this question to myself, that when this, my lord, 130
I'm
was,
trying to understand your
Yes.
question also.
was brought about,
Ah.
that the constitutional mandate at that point of time was very much in operation.
Correct, correct.
Whether it will have an effect or not, only that much. I'm trying to understand, my lord, this particular aspect. Otherwise, I'm not saying that 130A, my lord, will not apply. It is unconstitutional. It is bad in the teeth of the constitutional provision. But this is a, my lord, issue which requires, my lord, your lordship's
No,
consideration.
okay, you
Yes.
see, prima facie, I mean, I mean, we can, you see, if part 9B at that time was valid, then naturally 130A was illegal, invalid.
Not illegal. That is what I'm trying to say.
How can
It's
it,
not-
why can't it, why will it not be?
Illegal, my lord.
Why will it not be?
Yes, it will not be illegal.
Why?
Because I'm submitting, my lord. Firstly, my lord, there is a laudable, my lord, objective behind this act. My lord, there is a noble approach to, my lord, help out, reach out to the boards. Now your lordship will see 130 capital A, reading, my lord, in consonance with the constitutional mandate. By giving a harmonious construction, it becomes valid. Unless, my lord, once say that, my lord, the term of the board is transgressed beyond 5 years. So in terms of, my lord, 130 capital A, 41(2), if your lordship reads 41(2) only in respect of the disqualification, but not only in respect of the dissolution, then it becomes constitutionally valid. Well, that is in consonance with the mandate. There is a harmonious construction with the constitutional mandate, my lord.
But now why should we go into
Yes.
that debate?
I leave it to your lordship, my lord. This is the point which I'm trying to raise, my lord. So if your lordship, my lord, says, my lord, that if your lordship is not accepting this argument, then I will, my lord, argue in respect of 130 capital A, my learned senior may argue that.
Yes, but in a short, you can make a short reply to what he said.
My lord did not go any further. The unconstitutional declaration by the Supreme Court may have occasioned on 27/2021. That part was already interfered with by the Gujarat High Court, declaring it to be
That will not
unconstitutional
apply. That will
on
not apply.
15/2/2012.
That will not apply.
Yes,
The
the-
Gujarat High Court will, my lord, there are
just
decisions.
a-
Lordship, the Gujarat High Court by the impugned judgment dated 22/4/2013.
Where is that?
My lord, in the second paragraph of the judgment, my lord. My lord may have 1, 2, 3, 4, 5, 6, 7, 8 line, my lord, of the second paragraph. The middle. my lord, the
22 for, by,
Reasons are
22 for
decided by a
13.
division bench of the Gujarat High Court by the impugned judgment dated
22 for 13.
13 in whether part 2 is known as for want of ratification, so and so.
Yeah.
The impugned judgment of the High Court has been declared that the said constitutional amendment inserting is ultra vires the Constitution of India for want of requisite ratification under so and so proviso, which however will not impact amendments that have been made in Article 19(1)(c) and in inserting Article 43(b) of the Constitution. So my lord, when this 130 was enacted, the declaration was already there. It went up on appeal and it was confirmed only. So my lord, that argument will not lie. Now, if my lord comes to 130, now I'll try to take a word from my friend. Laudable object. What was the laudable object? It was the COVID situation and the problem in acting in compliance with any provision, because my lord, all things were relaxed at that point. Even the question of limitation was relaxed, my lord, approaching your lordship. Beyond the Limitation Act by the Supreme Court. Now, my lord, at the time when this act was enacted, why 2020, my lord, March 20? Because that's the date proximate to the, my lord, what suspension.
25, no, that was the day this thing was the total lockdown.
Lockdown situation started from that date, my lord. And when this act was brought in 2021, the COVID situation was, my lord, more or less the same. So, and on that day, when the legislature legislated this provision, it could not predict for sure as to how long the situation will continue. That is why, my lord, it had made, according to me, two distinct provisions, so that the issue can be considered with, and separated it with word or. This is something. Now, my lord takes up the provision 138A. In this background, my lord.
Just a minute. Yes, what did you say? Just last sentence, I didn't hear you.
My lord, the last sentence, what I'm trying to say is, my lord, when this act was 130 was, my lord, brought in, the legislature for sure could not say as to what, how long, my
How
lord,
long
this
the COVID would last?
COVID would go. So, my lord, it had the interest of the cooperative societies in its mind. And that is why, my lord, there are two different provisions given there. So that the whole scenario that may unfold in future can be taken care of. Now, my lord, the provisions that are being considered in 130A are section 39 and 41(2), my lord.
Give me that thing.
Cooperative Societies Act.
This one, Assam Cooperative. This one, no?
Small
Page?
book, Mali, yes. Lord. Now, my lord may come to page 36 of that,
Yes, 39.
39. A general meeting to be termed as annual general meeting of a registered cooperative society shall be held at least once in every cooperative year within a period of 6 months of the close of the financial year to transact. That means, my lord, within September it has to be held. To transact the business as provided in this act, the board shall automatically stand dissolved for not holding annual general meeting in accordance with the provisions of the act, bylaws within 6 months from the expiry of the very financial year. 41(2), my lord, would find at page 37.
Yes.
Elections, it comes under election 2, my lord. The election of directors to a board shall be conducted before expiry of the term of the board so as to ensure that the newly elected members of the board assume office immediately on expiry of the office of members of the outgoing board.
Yes.
So, my lord, both these provisions have a meaning, my lord, if we don't comply with it, it's gone. And my lord, in terms of 41(4), my lord, if we cannot arrange, my lord, will note the word where a board fails to arrange. Now, my lord, this is not included
Not included where?
in while considering 130A, my lord. 41, 2 and 39. So that is the act. That is the requirement. 41(4) is the consequence. No, you are now, my lord, by the state legislature, by enacting 130A, if my lord will forgive my words I'm using, just for my understanding I'm doing, it's basically concerned with the act that a board is to do. It's not concerned with the consequence, because the consequence will automatically follow. So, my lord, if the act is taken care of, the consequence is protected. The consequence will never come into operation, my lord. So, if 41(2) and 39 is taken care of, there would be no occasion for 41(4) to come into operation.
Yes.
Now, my lord, would come to 130A.
And where does it say that you're not allowed to participate?
That is, my lord, 41(4). 41(4), my lord.
41(4). No. Where he will not.
Oh,
be able
lordship,
to-
lordship.
he will not- he will
That
not
is,
be able to-
my lord. 6, my lord, 41(6). No. What does it do? আমি যে participate re-election করবো না। Yes, my lord. No. 40E. Lordship. 40, eligibility of a director in cooperative society. Subject to such condition as is specified in the bylaw, a member of the cooperative society shall be eligible for being chosen as a director of the cooperative society if, till, my lord, it goes till 1, 2, 3, 4. The period of 5 years has elapsed from such date. Such member cease to be a director for following reasons. Then, my lord, E, automatic dissolution under subsection 4 of section 41.
Section 44.
44E. 44E, my lord.
Eligible to be chosen.
Chosen, my lord. So basic provision is, my lord, 41(4).
Where?
Wherein, my lord, which says the consequence, and the further consequence is 44E, my lord. Now, if my lord comes to 130,
Yes,
my lord, will see the opening words. Exemption of certain provisions by general or special order. So, my lord, it's provisions. Now, what are those provisions? 39 and 41. I'll show that, my lord. The state government in exceptional circumstances like pandemic may by general or special order exempt any registered cooperative society or class of registered cooperative societies from the operation of the provisions. This is the provision talked about of section 39 and section 41(2) of this act, for such a period not exceeding 6 months at a time, which shall not be further be extended for more than another 6 months, as may be specified in the order. So the first exemption is, my lord, 6 months, 6 months, 1 year by a specific order. Now, my lord,
for such a period not exceeding 6 months at a time, which shall not further be extended for more than another 6 months.
as may be specified in the said order. So, my lord, it cannot go in terms of that from beyond 1 year, my lord. That's the thing. Now, my lord, we'll see. Or may direct that such provision here, my lord, is not this 1 year. It is that section 39 and 41. 2. Shall apply to such a society with such modification and for such a period, either from a prospective or retrospective date, as may be specified in the order, as per the need of the situation. So, my lord,
Yes,
here there are two provisions, my lord. That is 39 and 41. Now, these two provisions, the legislature wants to protect the both cooperative societies from operation of this and the consequence thereof. In a COVID time, when my lord, the end of the COVID, when it will happen was not known. So the legislature, my lord, first legislated said, okay, for 1 year, you can 6 months, 6 months. If that is done, finish. That's the end of the matter. Or may direct such provisions. And here, my lord, the authorities, my lord, want to read this provision as the provision of 6 months, 6 months. It's not. It's 39 and 41(2). Shall apply to such society with such modifications and for such a period, either from a prospective or retrospective date, as may be specified in the order. My lord will read these words, as per the need of the situation. I emphasize on that. So, my lord, if for that period 1 year it's taken care of, fine. You do it. If it is not taken care of, if there is a requirement of further, because, my lord, even in 21, we could not hold the meeting. Even though we were ready, I have shown materials, my lord. The meeting holding was not permissible because the government guidelines did not allow more than 200 people to assemble at a particular place. We have members more than 3,000. So the deputy commissioner was always rejecting our applications. And the department always required us that before holding, go to the deputy commissioner. So, my lord, this second part comes in. This is the place wherein the government can act.
or does it mean that the modification would only relate to the date when the 130 would apply?
It cannot, my lord. It cannot. Why I am saying so? 130 relates to 39 and 41(2). And, my lord, both of them operates every year, my lord. Every financial year, 6 months thereafter. This will come into operation. So, if within that period you can give him 2 extensions, if required, 2 extensions, it's not a prerogative, my lord, it has to be given. 2 extensions and they can hold the meeting, that's the end of the matter, my lord. If those extensions being given, still the meetings could not be held, not for any fault on part of the board, but because of the COVID situation, or my lord, the situation that followed it, then my lord, the second part was given. The legislative is very clear here. my lord.
Yes.
No, my lord will pause here for a minute and permit me, my lord, to place that additional affidavit. These documents were, my lord, but I have brought it on record. There are orders of this honorable court.
Additional affidavit?
Additional affidavit, my lord, page, my lord may come straight to page 120.
120?
One. Now, my lord will have page 125. Oh, my lord can have page 124, my lord. The orders I'll show, just give a gist, my lord. Yeah. My lord, this is a society, Ambari Sadubhasa Samabai Samiti Limited. Here, this first AGM election was held on 5/7/2015. The 5-year term came to end on, it should be 4/7/2020. But my lord, the AGM was permitted by the authorities to be held on 1/4/22. That means in the 7th year. Then my lord will have page 125. I've given a table at the bottom, my lord. 2 cooperative societies with the case numbers also. Fulsara Charalata SS Society and Moinbari Limited. Term was over on 16/5/20. Election permission was granted on 22/9/22. That means beyond that 7 years. Basically in the 7th year, my lord. And how it was done, my lord, the orders, my lord, would find at page 128.
Yes. Peter?
Page 128, my lord, with regard to 124,
Yes.
that Ambari Sodubasa,
Yes, yes,
the order, my lord, would find at page 128.
yes.
My friend appeared in that matter. It was argued and it was disposed of in his presence. Para 2, my lord. This order is of 10/9/2020. My lord will note that date.
Yes.
The board of directors so-and-so was elected in the annual general meeting held on so-and-so, and the member committee was formed on 12/7/2015. So, my lord, that 5-year period on 12/7, 5/7 or 12/7/2020.
So
6-year
that 5-year will start from the forming of the board, no?
board.
From
It
the-
should be
from
from
the
the date of
meeting.
election, my lord.
From the date of meeting or from?
Election. So there might be a confusion, my lord, election and date, but it's proximate. 4-5 days or 10 days, my lord, here, there it might be.
Yes.
But it's proximate to that. Now, here the direction was finally. My lord, page 131,
Yes,
para 12,
yes.
para 11. In view of the above, prima facie view can be formed that this is not the appropriate matter, wherein the authorities in the corporation department can invoke the provisions of section 41(4) and 41(6) of the Act of so and so. However, it is also a statutory provision that the term of the existing board would be for 5 years. Considering the matter in its entirety and particularly the conduct of the parties where the board of the society had concern had done the required arrangement from their side to hold the meeting before the expiry of the term. But it is the authorities in the respondents who have not responded in the appropriate manner facilitating holding of the election. We are of the view that ends of justice would be served if the so-and-so makes necessary arrangement for the board of directors of so-and-so limited to hold their AGM on a given fixed date to be notified and informed to all, and allow the Board of Directors to conduct the AGM for election of the new Board of Directors. In fixing the date, the AGM, Assistant Registrar shall take note of all requirements of law for holding such so and so. Till such AGM is held by the Assistant Registrar Cooperative Societies, the observation directions in the communication dated so and so, that the present Board of Directors has no locus standi shall remain suspended. AGM so and so, and the same manner, my lord will keep now the order, my lord. The order, my lord, would find at page 133.
Just a minute. Yes.
My lord would have page 133.
Yes.
This is the order. Chairman so and so, with reference to a subject, you are informed here that due to so and so, your society could not hold AGM election. However, as there is no restriction to hold AGM election at present, hence you are hereby instructed to adopt resolutions to hold so and so and notify the same among so and so within the stipulated time as fixed by the election authority, as ordered by the Honorable High Court. Probably date should not be later than 31/3/22. Probable notification date 10/3/22. Nomination date so and so, AGM election 27/3/22. Submit the so and so, and then my lord would have the second case. It will part. 135, it's fine. 136, my lord, is the second highlight which I showed at page, my lord, 125, which I showed, my lord. The Honorable Court, my lord, after discussing everything, at page 140.
Yeah.
Similar situation, my lord, the last paragraph. Herein also, my lord, notifications similar to ours were given, my lord. Accordingly, the writ petition is disposed of with a direction to the so and so to make necessary arrangement for the Board of Directors to hold their respective hold their respective annual general meeting on a given fixed date to be notified, allowing the so and so to conduct the so and so for election of new Board of Directors. The Assistant Registrar Cooperative Society, while notifying the date, shall observe all required formalities under law, and the annual general meeting shall be held by the existing Board of Directors, resembling the one purportedly fixed to be held on so and so herein referred. Now, my lord would see this order was passed on 22/3/2021 by this Honorable Court. Now, my lord would come to 141, my lord.
Yeah.
Here, my lord, the board's, my lord, thing expired on 16/5/2020. Now, my lord would see, this is written to us with reference to the order side. You are hereby again asked to fix another date within 45 days from the issue, holding the annual general meeting so and so, and intimate the same to the office so as to enable the undersigned to notify the date of election to the Board of Directors of your society. Fail to hold so and so within the given time, it may lead to contempt of court. This is for information necessary action. Now, my lord, here the board 5 years expired on 16/5/20. 6th year expired on 16/5/21. And this notification comes on 22/9/22. If these notifications were not proper,
Why not?
were not issued by persons having jurisdiction to issue it, and by exercising the jurisdiction vested in it, what actions have they taken? Because they cannot take the question of negative equality now, that was a wrong made, so we are following. What was the step taken? My lord, contend, going back to 130, it was done with that second part of that 138.
Or can the first part be construed also?
If they can do it, my lord,
No, no.
because
Can this for such period not exceeding 6 months at a time?
lordship,
which shall not be further, which shall not further be extended for more than another
6
6 months. Supposing we confine ourselves only to this,
Lordship,
is it only for 1 year? This one,
Lordship, what exactly happens here is, if that meeting is not held every year, 39.
no, I know.
39, the meeting is not held. There is why I'm trying to bring in that second part. 39, that meeting is not held for 1 year. Then, my lord, it goes. The effect is, my lord, if this extension is not given, 6 months extension and then 6 months extension is not given, it goes. So say, my lord, 2020, I had to hold the meeting. But because of this situation, still 22, I could not hold it. So it has to relate back to 2020. So 1 year, even, my lord, in one way, my lord, it's correct. What has fallen from your lordship, that even if they give that 1 year in 22, say that 6 months I'm giving you, hold it. It will be fine. But this 6 months has to be in relation to that 2020. Because we are in a limbo now, but it's not moving anywhere. But my lord, if the second part is brought in, then my lord, that bar is not there. There will be a
So
direction.
according to you,
Lordship,
these words, for such a period not exceeding 6 months at a time, which shall not further be extended for more than another 6 months, pertains to only 1 year.
1 year,
1 year.
1 year.
So it does not pertain to a period beyond 1 year.
My lord, if
No,
my lord,
I
I
think.
would be the most happiest person
Ah.
if, my lord, it can be interpreted in a manner
Ah.
that it can be given at any point of time for a period not exceeding 1 year.
Ah.
It need not be, my lord, 2020, it can be even given in 22 for a year or 6 months. Okay, we are giving you 6 months, hold the meeting now. Now there is no COVID, hold the meeting now. I would be the happiest, my lord. Because that will take care of my problem. But just, my lord, as an officer of court, I'm trying to just, my lord, show this, that even if, my lord, that first part is constituted, because he'll argue that, I know that. He'll come up with that argument, this is for 1 year, beyond this we cannot do it. Even if that is taken, my lord, then the second part, the only question here, interpretation that would be required, my lord, which, my lord, I will persuade your lordship, I pray that my lord will take it, or may direct that such provisions. Here the word provisions that is used here is not the 6 months, my lord. It is 39 and 41 too. The word provision used in the second line after
Yeah.
or may direct that such provisions. My lord has got it.
Yeah.
This provision is not that 6 months plus 6 months. This is 39 and 41 too. Now, my lord will see how that is worded. So, it's broader. The power is given. But you choose to apply it selectively. Now, my lord would see, may direct that such provisions shall apply to such society with such modifications and for with such a period, either from prospective or retrospective date, as may be specified in the order, as per the need of the situation. So, my lord, the orders that are passed, that I placed before my lord, it does not say 6 months. It does not say we are giving you another extension for, we have given you 6 months, we are giving you 6 months more. It's general order, my lord. It says that hold the election within this time, because you could not hold it because of COVID. Hold it within this bar, 45 days, 15 days, 20 days, whatever it is, my lord. That is in exercise of this second part of 130A.
You see this order
Lordship,
at page 135,
Lordship,
36 all this. It doesn't talk about 130A.
it did not, my lord, but the power flows from that.
I know.
Otherwise,
Now they are going to argue that this has been done on the basis of an order passed by the court
When?
without taking into account 138.
Fine, my lord will pass a similar order, let them act on that
No,
one.
no, I cannot do that.
No, I'm not on that, my lord. That argument would be fallacious because the orders of this honorable court were of 2020.
No, whatever it is, just come to 135.
Lordship,
Where does it relate to 130A? Where does it show that this order has been made in
the
pursuant to
High Court,
138?
my lord,
Yes,
High
yes,
Court direction.
yes.
High Court never went into. My lord is for the first time. The other cases wherein 130 is being sought to be, my lord, argued, it was never taken. 130 is being taken up by honorable single judge for the first time, my lord.
Is it? No,
Yes,
no.
yes, my lord. Yes, your lordship. In earlier cases, there were references made, but 130 impact was never considered.
So these orders
Lordship,
do not support your case with regard to whether, with regard to the orders not having been passed in pursuant to 138.
I'm not on
So
that.
this is not relevant.
I'm not on that. What I am on is the orders, my lord, which the government has passed,
Ah.
allowing them to hold the meeting,
Ah,
even in the 7th year.
ah.
I'm only on that.
Okay.
I'm not on the High Court orders.
So they're going to, so their argument can be and should be that this order that we have passed, allowing them to hold their AGM in the 7th year is on the basis of the direction passed by the High Court and not due to 138.
Fine. If, my lord, they had 138, I'll try to answer
So can
that.
you show me some document, some order passed by them showing application of 130A?
My lord, 130A application would be,
Separately, say 130A in the absence of any direction passed by this court. There must be some orders whereby.
there
they
would be, my lord, there would be, there
So
would be.
show me that because
ऐसे नहीं है लगा कि High Court order ना था क्या?
because this
Exception दिया.
the orders that you have
My lord, I have
And
brought it on record, my lord, prima facie to satisfy your lordship, that orders which were passed in 2020 were acted upon in 2022.
maybe,
No.
but
Well,
then right now when the issue is
Well,
130, why should we go into that?
I'll just take their stand. They'll say that High Court orders were there, so we were compelled to move it.
Correct.
But my lord, as an authority, they had 130.
They
And
have-
according to their interpretation, 130 is 1 year. What prevented them from making a challenge to these orders? Because these orders,
no.
otherwise.
Purportedly it has been done under 130A.
130
Purportedly.
even, yes.
But then it's not proved by this.
I'm not.
So
on
if
the
they
proof.
take a stand that it has not been done under 130A, then
My
we
lord,
have to abide by.
I'm not even, my lord, contemplating to draw them to that extent. What I'm trying to show before my lord is that there is an application for extension and permission. 5 years have completed in the 7th year also by the same body. I'm only on that matter because by doing it, you are exempting the cooperative society
Okay,
from 31, 39 and 41.
So
Two.
show me some orders passed whereby AGM has been allowed to be held after the 6th year
Without an order of this honor.
without, with, yes.
And
Without,
fortunately for the lawyers, my lord,
Ah.
in such situation, I have my doubts. All the cooperative society rush down to the court, my lord. Majority of them. They come down here and there are litigations pending. It would be a very rare situation wherein, my lord, a cooperative society has not come up before your lordship and the government has allowed it. It would be a rare. Even if the government wants, there would be a
or
case before your lordship.
is there anything
Lordship.
in those writ petitions, the orders that you have mentioned, which refers to 130A?
Because, my lord, why I'm saying
Because
so,
then the
lordship,
so-
because the first order which came,
yes,
my lord, 130 would do.
so that it can be inferred that these orders were actually made on the basis of 130A.
Lord,
And most probably it is also.
it is
Because,
the power, my lord,
I don't think a high court will just, but there's a court of equity also, so it can be done. But then,
it can, 135 page. My lord would have the order at page 127.
yes, I've got it,
My lord, this order was passed on 2020,
correct,
10/9/2020,
correct.
Here, the amendment will not be there because the
Correct.
amendment came into effect
21.
in 21.
Yes.
So the,
So this has not been made in the basis of
No.
138.
no, cannot be,
So
it's gone. But the action on your part, on their part, because the court said that you do it.
no, action, no.
My lord,
That
then
is
come-
speculative. That is speculative.
Then my lord would come to the next order. This is a writ petition which was, my lord, disposed of on
This is also prior to.
prior to.
prior-
But my lord, their actions after 2 years.
Maybe, but
Because-
still there is a valid order.
My
passed.
lord, if in between this one
No,
thirty
no,
had
no,
come,
no.
no, my lord, if the order of this honorable court. If this order of the honorable
You
court
see,
were all,
you see at page 141.
lordship,
You see the reference.
yes,
The
order number,
reference is on the basis, the order has been passed on the basis of the High Court order.
fine, 23/3/21
Yes.
and a government order 9/6/21.
Yes. Now let
Then
us,
This
if
office order,
this, let us see this 9/6/21 or the 2/11/21.
that
Does this,
my friend can produce, my
so
lord.
if this, does this relate to
130,
138?
my lord can have that
That-
view,
Now leaving that aside,
lordship.
there is another aspect. I think some impugned orders have been issued in all your cases.
Yes,
You all have been dissolved.
dissolved. One man committee have been done,
One man committee made, huh?
lordship.
Uh,
And my lord will have the impugned order, my lord, before my lord takes a call on that 118, my lord. What is the reason?
Just a minute. What is the order dated?
It's 18/3/2023, my lord.
18/3/23. Now, and what about this other in 18/63/2023? What is the,
I'll give the dates.
just give me that.
My lord, the order is a common order.
How
By
much-
the district wise,
But- But there will be different dates.
No, there will be different dates, my lord, it will be
There will
for
be.
districts, my lord.
The order is a common order passed by the additional, my lord, registrar. in
Same order,
respect of-
additional register of cooperative societies,
But I
Kokrajhar.
just want to know the date.
18/3/23, same order, my lord.
18/3/23 in all the
the
five
cases.
petitions.
One order.
18/18.
No, same date,
Same day,
same date,
same day,
or same date.
same day.
Common order, no? Common order,
18/3/23, common order.
Kobita Ranidas,
If it is same date,
lordship.
then for those okay, 17/6/22. Then for those cases where they have not completed 6 years. Why wasn't this thing
1 year
given?
given. And my lord
Why
will just
wasn't 130A given? That is one issue.
one issue. And my lord will come to 118, my lord, the result.
118.
They can't go beyond this, my lord. They'll have to stick to this.
Yes.
Peruse the letter dated so and so and so and so, so and so. On perusal, it appears that the, my lord will see the reason. The following cooperative societies under Dhubri subdivision are not able to conduct AGM and election as per provision of the Assam Cooperative Act due to COVID-19 and due to the High Court matter, for which these societies have attracted automatic dissolution as per section 39 of the Act.
So in all,
All. So you have 130 with you specifically for this purpose, which you have been, my lord, either directly or indirectly applying in other societies. What prevented you, my lord, from applying that here? If that is the reason, if there was some other reason, it would have been different, my lord. And that is exactly why 130A was, my lord. I'll just taking a second alternative plea, my lord. If this is the reason, then I'm covered by 130, my lord. Without acting under 130, you cannot resort to this. And 130, two parts, my lord. If the first part is not being satisfied, come to the second part,
okay, since you have been dissolved
lordship,
and a one-man committee is there,
lordship.
would you have a problem if this court directs that AGM should be held and you can participate in the AGM?
My lord, there will be no problem. There should be no problem. But the problem here is, if this one-man committee holds it, that's my instruction. my lord. That's why the problem, our coffers would be empty, my lord, by the time the election is over. This is, my lord, my instruction, I can't prove it. But our coffer, my lord, it's a fact, my lord. It's a
maybe
fact.
a fact, but that is because.
My lord will not even consider that. My lord did not even consider that. But that's
That's a
the
different
practical reality.
That we don't know.
My lord will not even consider that. And the legal problem now is, my lord, if this cooperative society, my lord, we are an independent body. We have been elected body. If we have not committed any wrong, and because of these circumstances, my lord, we have been forced, even after, my lord, arranging for holding the election, we were not permitted. Now you apply that 39 and 41 on us, whereas you yourself have enacted 130A to exempt us from that provision. Now, my lord, what made you to go without applying 138A to appoint, my lord, officers overnight, and that too by recording a finding that because of COVID and, my lord, High Court matters.
Yes. Okay.
And, my lord, when the earlier round of litigation, orders are there. There are orders, interim orders operating that we'll be exempt. We should not be, my lord, this virus should not be put on us. In the teeth of that, these orders have been passed by. And there are contempt.
So all these orders have been issued in March 23.
23.
Yes, that's all. Anything
That's
else?
my mind. Well, I'll just have some water and come back. Speaking of it.
Please have, please have. Don't have to come back. You can drink here. You can drink here also. Yes.
May I please, your lordship? My lord, basically, the interpretation of 130 capitally is involved.
Yes.
So your lordship has seen that there are two parts,
Yes.
and this 130A, my lord, it deals with 39 and 41 too.
Yes.
And essentially, my lord, 39 is not that relevant
Yes.
because 39, it deals with the yearly AGM.
Correct.
Here is a case of election, not.
But election is held during the AGM, or is it? No.
No, my lord, I am trying to, my lord, in fact, crystallize it. 30, your lordship will see 31. My lord, the relevant provisions are 31.
Just a minute.
31 is more important, which has not been drawn your lordship's attention.
Yes.
31 will have a role, my lord.
Yes.
Now, 31, and your lordship will take note of one aspect of the matter, that this, my lord, act has come into force in 2007. Earlier, my lord, the repealed act is of 1949. 1949. And the judgment, my lord, Rajendra Shah's case, it reflects, my lord, that pursuant to the constitutional mandate, more than 2/3 of the states, my lord, have, my lord, enacted their new law in terms of the constitutional provisions, my lord. And this is one of them.
Maybe.
No, I'm not on that. I'm not going back to that. I'm just, my lord, indicating. Now, 31 is pursuant to that constitutional mandate. 31 says the term of the board shall be 5 cooperative years from the date of election of the directors. So the counting of 5 years, my lord, from the date of election. So 41(2), my lord, has a relevance with, my lord, 31. While considering 41(2), your lordship has to take into account 31 also. The counting, my lord, is from the date of election. Now,
And this has relevance to 40 also, 44E.
yes, yes. My lord, I'm coming to that because, my lord, here your lordship will see the consequence is twofold. My lord, under 39 and 41(2), the consequence is twofold. The first one, my lord, is dissolution of the board. The board shall stand dissolved.
Correct.
And the second one, my lord, is the disqualification of the members
From participating
in the election.
in the
So-
next week.
This is the right against which, my lord, there will be prejudice.
Correct.
Otherwise, your lordship will see the mandate of the shareholders is for a period of 5 years.
Correct.
Nobody can claim
Correct.
that I am required to retain beyond 5 years.
Correct.
And I'll come to, my lord, the division bench judgment of this honorable court, which has considered 39, saying that, my lord, 39 is absolutely mandatory, but it is before 130 capital A. But this becomes, my lord, this has a significance. Because 39 as well as 41(2), my lord, has to be considered a mandatory provision, my lord. So the argument would be, my lord, my argument would be 130 capital A, my lord, has to be given a restricted meaning. So that the broad interpretation, my lord, does not render two, my lord, provisions, mandatory provisions as redundant, my lord, and odious.
In that case, why didn't you challenge the judge, the order of the single judge? In the,
No, my lord,
This is-
my submission is a legal submission based on 130 capital A. What I'm trying to say, there is an express provision, my lord. First part is express. Now, your lordship has to read the second part, my lord, along with the first part. Because here the doctrine, my lord, of eis dem generis will apply. My lord, the latter follows the former. Eis dem generis, my lord, I'll place a judgment of the Madras High Court, my lord. The latter follows the former, and my lord, when a legislative, my lord, intent is not clear of a, my lord, particular expression, my lord, it gathers each scholar, my lord, from the associated words. So this is the principle of eis dem generis, my lord. So your lordship, my lord, has to give a restricted meaning, and thereby your lordship has to hold that, my lord, the latter part will follow the former, because otherwise, my lord, the very scheme, my lord, will be defeated. What is the scheme, my lord? The scheme is, my lord, democratically they are elected. They have, my lord, a tenure of 5 years. Otherwise, my lord, irrespective of 130A, if 130A is not considered, they cannot remain beyond, my lord, 5 years. The mandate is for 5 years, my lord. And if your lordship says 41(2), this is not in respect of term, my lord. This is in respect of, my lord, holding of the election. My lord, this is very important. So even if, my lord, that is exempted, 41(2), even if it is exempted, it does not talks about the term. Term, my lord, 31. 31 is parallelly operating, my lord, along with 130 capital A.
but then, you see, if 41(2) is not done, then what happens? Then they become automatically ineligible to participate
Yes, now,
under 44.
yes, no, there is a
Then-
division bench judgment, my lord, saying that if the failure cannot be attributed to them,
Hmm.
there is a division bench judgment, my
Ah.
lord, cannot be attributed to them, that then the consequence will not follow in respect of the disqualification.
So what
lordship
is,
will
so,
apply that one.
so what
I
is,
have no
so what
objection in
is,
that
so
respect.
what is your submission?
My submission
In
is
terms of the division bench judgment, you will allow them to participate.
participate. That is my submission, my lord. They are, my lord, entitled to participate. Now your lordship will come to 130 capital A. My lord, it is very clear. There is disjunctive part, my lord, has to be read in terms of the express part, my lord.
Yes.
My lord, my submission is the latter part of 130 capital A has to be given a restricted meaning. The broader interpretation, my lord, would be amounting to do violence, my lord, with the entire scheme. So it has to be confined, my lord, to the first part. Now, your lordship will see the disjunctive part. First part, there is no problem, my lord. This is, my lord, express part. My lord, if we start from or may direct that such provisions shall apply to such society with such modifications and for such a period. So only this part, my lord. Then there is a continuation, my lord, to the entire, my lord, enactment. This is, my lord, the other part is continuation to the first part also, either from a prospective or retrospective date, as may be specified in the order as per the need of the situation. So this need, my lord, is, my lord, applicable to the first part also,
Now you tell me,
my lord.
so this second part, according to you, is the same as the first part.
I am trying to say, my lord, that the second part would follow the first part.
would follow, but how, what is the need for putting the second part in the
Yes,
first place?
The need, my lord, is that 6 months may not be necessary. My lord, suppose your lordship will kindly see, if extension, by granting extension of 1 month or 2 months, it serves the purpose, then my lord, 6 months or 6 months may not be necessary as the need of the situation, my lord. And viewing from another aspect,
How
my lord,
does, I mean, if the first part
my lord,
takes care of all situations, what is the requirement of the second part? What is the, what different situations is it looking at?
my lord, the first part is very clear, 6 months and 6 months.
No, it's not very clear. It says for a period not exceeding 6 months
Yes.
at a time. So it means it can be given for 1 month also. It
Yes,
can be given for 10 days. So if this first part takes care of all situations, what is the need for giving the second part?
This can be, my lord, for prospective or retrospective. From a prospective or retrospective date.
You see, or may direct that such provisions shall apply to, okay, yeah, supposing we accept that. However, the problem arises with the use of the word and.
My lord.
If there was no and, that's okay. But when it says or may direct that such provisions shall apply to such society with such modification,
And
then it says and for such a period, either from a perspective. So it's and is now, I think, coming in your way of your submission.
as per the need of this.
And for such a period.
Now there is another thing.
Well.
The section 130A was gazetted on 9/6/2021.
21.
It is, and as per your submission, the 1 year period that can be provided under section 130A is only for 1 year, correct? The
Yes.
period that can be extension period can be only for 1 year. Now, however, the 130A by itself, though gazetted on 9/6/2021, is given retrospective effect from 25/3/2020.
2020.
So, if it is only for 1 year, it could have been applied only from 25/3/2020 to 24/3/2021.
After that,
However, it was gazetted in June
My lord.
2021.
Retrospective effect has been given.
Ah.
Correct.
Now, so if it was to be applied only for 1 year, now if it is given in 9/6/2021 and applicable for 25/3/2020, and say some cooperative society, its term ended somewhere around that 25/3/2020. Then what would happen to it?
My lord.
The 130A would not be able, it would not be workable or could not be applied against those.
and that period, my lord, COVID was in full swing.
Well, full swing. So if it's applicable, then that, if it was meant for only 1 year, then it would have no purpose because it would have to be applied only till 24/3/2021.
That is why the second part.
Unworkable.
It cannot be unworkable. my lord.
Huh?
No legislation can be unworkable. It can be made workable by bringing in the second part.
My lord, my submission is this.
No, I just,
Yes,
it's just
yes.
my
It's
thinking out loud.
I'm
Yes.
thankful for that, but I did not click that time. Now, my lord, I have got that also.
Because your lordship will see, my lord, if it is allowed to continue, if the board is allowed to continue, then also, my lord, there are some mandatory provisions which will, my lord, automatically become redundant. So therefore, my lord, the scheme, my lord, having regard to the scheme, my lord, this 130 capital A has to be given a restricted meaning.
No, I'm okay with it.
Yes,
I
that is my
understand, I
submission, ma'am.
understand the anxiety.
Yes, yes.
But now think of a situation. If the COVID pandemic was still applicable or still being applied till today,
Yeah.
then what would happen?
My lord, I will, my lord, submit in this.
Then
Yes.
130A would have been of no use again if it is only for 1 year. Suppose, because no one could say on the date that it was made effective or on the date it was gazetted, that COVID will finish in 2 months or 3 months or 1 year or 2 years. No one could say.
My lord, my submission is, my lord, here, your lordship, my lord, has to read that essentially 41(2) does not extend their term, but it deals with, my lord, the disqualification.
Correct.
So therefore, my lord,
No, it indirectly, it indirectly extends that term.
because we have to draw a line, my lord.
Because,
Otherwise, my lord,
Uh,
they are right,
uh.
my lord, they are right, my lord, in terms of the mandate for a period of 5 years. So therefore, the other part, my lord, regarding the disqualification, that can be taken care of in terms of 130 capital A. Because the exemption is 41(2).
So according to you, if it is only with regard to 39
My lord.
and 41,
Yes.
then they cannot be in office. Then if they cannot be in office, where is the question of application of 130? They cannot call for an AGM.
My lord, what I'm trying to say, so far as 39 is concerned, my lord, there is no problem. Because 39 does not deal with section 31.
Correct,
31 is with regard to the
correct.
term.
But what about 41?
41(2). My lord, what I say, 41(2) expressed, my lord, provision, my lord, is in consonance with the scheme, 1 year. Now, if we, my lord, make it broad, my lord, if we don't draw a line, then, my lord, the problem becomes, because it is essentially going to, my lord, damage, my lord, the scheme and the mandatory parts of the, my lord, act. So therefore, what I'm trying to say, while interpreting 130 capital A, your lordship will, my lord, interpret the latter part, my lord, along with the first part, and applying the doctrine of age generis.
No, but the problem is when we are applying it,
Well.
you think of it in terms of the Gazette notification of 9/6/2021.
Right.
And the date it comes actually into force, that is
1 month.
with retrospective effect on 25/3/2020.
By
So-
this time, 1 year is
One
already
year
expired.
gone, 1 year gone.
Yes.
So if there was some board which were requiring the application of 130A on 25/3/2020 or say in April 2020, the 130 would have been issued to them
All those
with
boards, my
retrospective
lord,
effect.
all those boards came and your lordship has seen 2 orders. That's
Ah.
my learned senior
Ah.
friend has pointed out.
Ah.
Nobody were waiting, my lord.
Ah.
They have already approached this court and got the orders before 130A was gathered, my lord.
Yeah.
Everybody, my lord, yes. This is
And
my
we were
learned friend is
here.
also
We
considering.
were also before the court.
No, but then subsequent to, I think subsequent to 9/6/2021,
Right.
you all have issued, I have seen earlier, you all have issued orders under 130A.
Pursuant to, my lord, this one.
Huh?
No,
Pursuant to 130A.
no, my lord, what I'm trying to say, there was a series of litigation.
Uh-huh.
Thereafter, my lord, on the last part of 21, this honorable court directed the government that pass orders under 130A. Pursuant to the, my lord, batch of writ petition, the government passed an order. And it was, my lord, I think in 2022 first part,
Now,
pursuant to the direction of this court, my lord.
okay. So this is, that is, so where is those orders?
My lord.
Where is those orders?
Those are disposed of, my lord.
You give us.
No, page 32, my lord. Page 32 of this writ petition.
Yes.
So, yes, it is an my lord. Sorry.
My lord, this order was issued on 21/9/2021.
No, my lord, no. There is a batch of writ petitions.
No, no,
passed
no,
by
I'm coming
Justice,
to
my
that.
lord,
Those matters are pending.
Justice M. Chaudhary.
Madhu Salmari, SS Limited, page 32.
No, I'm my lord on a different order, my lord.
No, I'm just clarifying.
Anyway, even in this order,
Huh.
this page 32, extension with effect from 4/9/2021.
My second one is mine, my lord.
Up to
Madhu
3/3/20.
Salmari, 19/8/21 to 14/2/22.
Now, 4/9/2021, 3/3/2022.
19/8/21, it was given, my lord, from 19/8/21 to 14/2/22.
Yes.
Then, my lord, will have page 37. We immediately, my lord, convene, took steps.
My lord, these are regarding AGM.
No,
AGM.
AGM come election. Page 37, my lord, has got.
Yes,
On 17/12, we held a meeting that we will hold the election on 31/2022.
yes,
That, my lord, resolution 1, last slide.
yes,
Now, my lord, will come to 43.
yes.
Second line, second paragraph. And whereas letter has been received from the secretary so and so seeking permission to hold so and so on 31 with 3,167 numbers of shareholders. Last paragraph, my lord. In view of the above, application for holding so and so society on 31/21 with so and so is hereby rejected. Thereafter, that second
Anyway,
extension.
so you want to make some more submissions or
I'll
Finish.
make some more submission.
then add two then?
My lord.
But how long will you take?
My lord, half an hour. I have to place some judgments, my lord. Division bench judgment, or your lordship may take some other day, Tuesday, my lord.
Because we are still in the motion stage.
Lordship,
We've got number of cases.
Lordship.
I want to finish at least the motions.
Lordship may take up on Tuesday.
Because we've got
My lord will finish the motions and then make a try, my lord.
we'll finish the motion and then
My lord, that will be more convenient.